Mm.
Yeah, I'll sit here. This is where they're coming. So a new one?
Yeah, this,
Thank you, Mr. Chairman. Commerce Committee, nice to be back. Mr. Chairman, Mr. Chairman and I spoke earlier in the day because he knows I have to take a plane tonight and go somewhere. So we're having a nice chat, and I'm working late last night, and I'm in a good mood. I'm getting all my stuff done so I can go away for a couple of days on business. And at 8 o'clock, 8:08 last night, Mr. Chairman, I get an email that tells me the speaker has chosen myself, Representative Almy, and SciTech for a condominium committee, and I know you had something to do with it. So, you've been a great mentor. I've been a good student. We've been seatmates. We get along pretty well. I don't know what I did to you to receive this pennant, sir. Mm. Anyway, thank you, Mr. Chairman. I didn't have anything else to do, but now I do, so thank you. My name is Representative Will Infantine. I represent Hillsborough 16 in Manchester. And I'm an insurance agent by trade, but I've been involved with condominiums for the last 30 years of my life, having owned some as well as being on the boards of some. And one of I want to give you some background of what this bill is about. The last time we went through a recession, we had a number of condominium associations where they had units that were foreclosed. And the banks were not doing anything about it. The financial institutions would not foreclose, and there were no payments for condo fees being paid by those units. More often than not, the association would have to keep those units heated because you have, especially in townhouses or what have you, you have utilities that go through all of them, so you can't just, shut off the heat in one. And there was actually a term coined, I think, by the Wall Street Journal called zombie mortgages. Okay, where the banks wouldn't do anything about them. And you all know if you've ever had a mortgage, you sign 20 pages, and on each page it tells you all the terrible things they can do if you're late by a day or all these other things that go on. Yet when it came down to a situation where a unit was for some reason abandoned. The people had either lost their job or divorce or medical issues, and they were no longer in the unit. The financial institutions would not foreclose. And that harms the rest of the association. We did have a sister type of bill that was passed by this committee in the House a number of years ago, which allowed condominium associations to at least put a lien on a unit for up to 6 months of condo fees, because what would happen is if the unit was vacant, it was abandoned, the financial institution would not pay the condo fees, and as soon as they foreclosed, it wiped it away. and the associations would be out these fees. Actually, we came to terms with the folks at the Banking Commission because they realized that a healthy association is good for every lender, for every unit. So if you have one or two bad apples, it's not good for the whole. And they did agree to that lien, and that has been in place for the last 3 years. And I don't think there's been a hint of any kind of an issue with that since we put it in place. So this is kind of the next step. What do you do when a financial institution will not foreclose on a property? The condo association continues to pay, and it, you know, it's kind of taking from the rest when they're not doing fulfilling their obligation. Now, I'm also a nice guy, and I don't want people kicked out of their condominiums either. People fall on hard times. Sometimes it's a very short period of time. So while this bill does not have it, what I'm going to propose in it at this point, if you look on line 3 of the bill, 356, Roman numeral 11, any suit to enforce any lien preferred under paragraph 3, I would add for a condominium abandoned by the owners. I don't want to force this issue for people that are just trying to maybe had a short-term situation and are trying to get their way out of it. This is for people that have said, look, I'm sorry, for some reason, any reason in their life that they can no longer afford this, and they are leaving. They are taking their stuff, they're going, and they're abandoning their unit. I would like to make it that narrow. Because one of the things, and when we brought this bill up in previous years, people have talked about is, well, you know, you get some people that are behind by 3 or 4 months, and you get some people on a really uncomfortable board, and they're just going to start that foreclosure process on these people because they're angry with maybe something else that they did. Maybe their dog barks too much or something like that. I don't want this to have anything to do with that. This is for people who have decided that they can no longer stay there. They cannot afford it. I do know this goes on. I have a friend of mine passed away in a car accident 4 years ago, and I took on his estate as an executor. And he had had some issues, and he had not paid his mortgage for 4 years. It took me a court order from the Hillsborough County Probate Court to get the bank to take the house back so I could get on with the estate. They just wouldn't do it. Finally, a law firm in New York, they're actually angry with me when they talk to me on the telephone. How dare I do that? I'm like, well, all due respect, I'm trying to close this estate, and he hasn't paid in 5 years. Would you please take it back? So unfortunately, this does happen. And this was 3 or 4 years ago when the economy was fine. I understand financial institutions sometimes don't want to put this on their reports because every time you have a loan, if you know anything about bank reports that have to be done by the feds every quarter, you have to list how many of your loans are 30, 60, 90 days late, and how many are you going to write off. And I understand in a bad time they don't want to inundate that report to the feds. Well, I'm sorry. I get that, but you're not helping the entire condominium. And I know my friends at the banking lobby are going to be against me, and I call them my friends because we usually get along on everything. We usually agree on most things. This one, we're not going to agree on because I do believe if you have 1 or 2 units that are not paying their fair share, the financial institutions are also not paying that fair share. They're kind of taking away and making the other unit owners have to pay for that expense. And I don't think that's right, and that's what we're trying to put an end to. Sorry to bring such a riveting issue to you at 10 a.m., but Mr. Chairman, that is my testimony.
Okay, so just for a little edification for the committee members, this has been an issue over many of my years of having condo bills come to this committee. And the resolution was really driven by Fannie Mae, who decided that 6 months was the right number. And so we thought that was great, and we passed that legislation, and it's been on the books for a fair amount of years. Yeah. So what's different? I mean, Fannie Mae hasn't changed their mind, so why would we want to revisit this issue?
This is not revisiting that issue, Mr. Chairman. That issue had to do with condominium fees that were not paid, and it allowed the association to put a lien for 6 months worth of condominium fees. In the event of a bankruptcy or foreclosure by the financial institution, the lien would still be there. and the association would be able to retrieve some of their money. We also found out that once a lien was placed, usually the institution, I don't want to say woke up, but got an idea of what was going on, and they usually tried to address it. And more often than not, they paid those 6 months to get that lien off. This is totally different. This has to do with when a unit is vacant. It has been abandoned by the unit owner, and the bank will not foreclose on it and put it back out for sale. It allows the association to do that when the institution will not.
Not that I want to, debate semantics, but this was an issue of super lien that that the foreclosure responsibility is the bank's foreclosure, and you are now who technically your lien on fees is a second, the condo association's the second, and so you are asking to jump over the bank and to force that foreclosure when you're technically the fees are only a second lien rather than the first lien, which is what the financial institution has.
I'm pausing only because I want to make sure I don't say the wrong thing, and I believe what you're saying is correct. But there will be an attorney speaking after me that may be able to better answer that question for you, Mr. Chairman.
Okay. Any other questions to the committee? Representative Thaxton.
I have rather extensive experience with this problem. In the REO world, real estate owned.
So this is a would you believe, or are you asking a question?
I think this is the question that I have for the petitioner is this. Is it my understanding that the intent of this bill is to prevent a situation where a bank may or may not have chosen to foreclose on a defaulted mortgage where the property has been abandoned for some period of time, from 3 months to 3 years, and to not allow those homeowners association dues to accumulate unpaid and uncollectible?
Yes and no. The first part of your statement, yes, it is to allow the condo association to bring a foreclosure, but not necessarily for that 3 months to not, I think it was a year, but over a year haven't been paid their fees, but it's not necessarily to collect the fees. That's where there's a difference here. The first one was to be able to collect the fees, the bill that was passed 4 or 5 years ago. This is to take an abandoned property and to force a foreclosure when the financial institution won't, so it can then be put back on the market and be sold, so the next person can own it and pay their condo fees. This is to do it when the bank refuses to do to initiate the foreclosure.
So the
Further question may inquire.
I'm sorry. Further, so this allows the association to do a foreclosure? Is that what we're?
Correct.
Got it.
And there's a lot of notice in here, and there is a law in the Commonwealth of Massachusetts and some other states, so this is not a novel idea that we're just trying to bring to New Hampshire to see if it works.
Okay. Representative Burrows.
Thanks for taking my question. I'm just wondering about what the definition of abandonment is, and obviously if somebody's cleared out all their stuff, that's a strong indicator. But I'm wondering, is there a set criteria for this? I'm thinking maybe somebody who's gone off on military duties, somebody's gone off to take care of a elderly parent, maybe gone for months, or they're sick themselves. So what protections do we have for those folks?
The language I proposed does not define abandoned. If this is something the committee is willing to move forward for with the codicil that it would be only for abandoned properties, I would add a definition of that.
Okay. Representative Gibbons.
Thank you, Mr. Chairman. I need a clarification, and then I'm going to have to ask for a further inquiry as well. First of all, for clarification, we are discussing HB 178, and the reason that I ask is because the one that I read over the weekend and actually did some research on says nothing about abandonment. So this is HB 178, and if so, could you tell us again the exact language about abandonment that you would add and where you would add it?
Yes, it would be line 3 of the bill. It starts off Roman numeral 11A. Any suit to enforce any lien perfected under paragraph 3 or a condominium abandoned by the owners shall be, and that's where it would that's where it would segregate.
Or a condo abandoned by the owners, okay.
Okay,
And then I do have a
further question?
Yes, and here I'm just going to use some information that I'm personally familiar with as an example on which I base my question. As I understand the bill and some research I did over the weekend, current legislation provides that a lien for unpaid condo fees may only be for 6 months of unpaid condo fees. And I live in a condo in Concord, and so using my own information as an example, 6 months of condo fees is a little over $2,000. At the same time, the most recent sale of a unit in my condo development was for more than $200,000. So this would appear to allow the foreclosure and sale of a $200,000 unit for $2,000 of unpaid condo fees. And how would you address that and make sure that you are protecting, for instance, individuals referenced in the earlier question who might be away because of military duty or be long-term hospitalized and perhaps have appeared to abandon their unit, but in fact not have intended to do so, but might be deprived of a $200,000 unit for lack of payment of $2,000.
The protocol in the law does not allow for the association to keep any of the funds in excess of what they're owed. Okay, it would go back to the financial institution in the event of foreclosure. So it's not entitled to be a windfall where, hey, we get $200,000 for a $2,000 condo fees that are owed. That is not the way the whole process works. The comment you make about someone in military service or someone away, it's a valid point. In an association, pretty much everyone knows what's going on with someone, and when the association, the board of directors usually knows. I've never heard of a situation where, at least in Massachusetts, where this is done very abruptly, that people don't know what's going on, and they know when the unit is empty, people have moved out. It has been gone for a certain period of time. The association has had to enter the unit to keep the heat on and is paying the utilities. Under that is usually what happens, and that's when they know it's abandoned, and they would utilize this law.
Further inquiry?
Further question, you may inquire.
Thank you. My question actually was not intended to address the question of windfall. I do understand your point about that. Nevertheless, and sure, most of the time the condo board will know what's going on, but none of that is perfect. In order to avoid someone actually losing a $200,000 home, regardless of the windfall question, would you be open to adding a provision that would allow foreclosure only when the unpaid condo fees were either a certain dollar amount or a minimum certain dollar amount or a minimum percentage of the worth of the unit in question?
Maybe the former, but not the latter, where it's a certain percentage of the value. I'd like to not further answer that question, only because I am not a lawyer by trade. A lawyer will be testifying. and knows the whole protocol of what you have to do, the notifications that need to be done, the certified letters, all the things, the protocols that need to be done with notifying the bank and everything else to make sure that you're not going to do some of the things which you are fearing that might happen. And I just don't want to muddy the water when I think a more coherent answer can come after me.
Excuse me, one more further inquiry?
We will be doing a subcommittee, so,
Very last one, I promise.
okay.
Thank you. And that all makes sense. But back to the question of the person who's in the military or in long-term hospitalization, while the bank would certainly receive the notice, owners in those circumstances might not receive the notice. So how does that provision protect the owner?
I'm sorry, again, I'm not trying to deflect your questions. I just know that someone knows the law, the current protocols, the checks and balances much better than I, who can better answer that question in a few minutes when I'm finished testifying, and I'm sure they will, because I'm sure they're taking notes.
Thank you.
So, make sure that person has a pink card. Thank you. Okay. Representative
Thank you, Mr.
Miguel.
Chairman. You mentioned that a bank might not want to carry this on their balance sheet, so to speak. Is there another reason that they might not want to do a lien or a foreclosure right away, and that they didn't think that they could resell the property right away? So is there an option that the bank could basically start paying for the electricity, the fuel, the condo fees, instead of foreclosing, so they could hold it off for a while? But of course, in that case, I would assume that they would have to carry it on their books.
I think we would all rather that the institution, financial institutions, step up and pay the condo fees and pay the utility bills and do that. You are spot on with your estimation of what occurred years ago. The appraised values of some of these condominiums fell below the amount of the note, and they did not want to put it on the market until the market recovered. I respect them wanting to do that from a business decision, but again, it's all fair in love and war here. That might be a good decision for the bank, but how does it affect the association?
Okay, and yes, Representative Filio.
As I understand it, one of the purposes of this bill is to help the condo association to recoup costs such as heating costs after a unit is abandoned, because the association needs to heat that unit to keep the entire block heated. Does the association also continue to pay heating costs after a unit is vacated after a voluntary vacate, such as when tenants move out?
You know, it all depends on the situation. Not every single association is built the same way that it has common utilities. The ones that would, yes, the association would have to step in because they don't want the power to go off. So they would do that. But you have to think of, you have 100 units. Everyone has 1/100th of the obligation to pay for the landscaping, the plowing, the new roofs, all the expenses associated with that association. When 1 or 2% those aren't doing it, everyone else has to pay the difference. So that's what we're trying to stop. But direct answer to your question, it all depends on how the association is built. And yes, the association does have to take, especially for insurance purposes, whatever means necessary to keep it heated so you don't have frozen pipes and cause an insurance claim.
Great, thank you very much.
Thank you, Mr.
All
Chairman.
right, now we'll hear from the other side, the bankers, New Hampshire Bankers Association. Ryan Hale and Rob Diddle. I guess I should have paid more attention when you introduced yourself to me.
The first one. Well, good morning. For the record, my name is Ryan Hale, Vice President of Government Relations for New Hampshire Bankers, and with me today I have Rob Dietl, President of the Gallagher Firm. Chairman Hunt, honorable members of the Commerce Committee, New Hampshire Bankers represents 38 member banks that employ nearly 6,000 employees. We come before the committee today to provide testimony in opposition to House Bill 178 relative to the enforcement of condominium liens for assessments. As introduced, HB 178 would increase condominium associations, current volunteer condominium boards, the right to foreclose upon and evict condominium unit owners for unpaid assessments, and that's as currently written, regardless of the amount that's owed. This proposal goes well beyond the 2010 compromise that created existing statutory priority lien rights for unpaid assessment fees and allowed condominium associations to require unit owners that to escrow up to 6 months of fees if they so choose. For committee members who are returning, this all may sound familiar. In 2021, a nearly identical bill was introduced, House Bill 426. This committee unanimously recommended an expedient to legislate with an 18-0 vote. And then again in 2019, a nearly identical proposal was brought before the committee, HB 436. It also failed to get your endorsement and was recommended an expedient to legislate with a 19-0 vote. Again, condominium associations already have less drastic options at their disposal, neither of which would require such a significant policy change. As already mentioned, associations can require unit owners to escrow up to 6 months of assessment fees, providing a cushion when delinquencies arise. Additionally, they can limit access to common areas such as gyms, pools, parking, to encourage unit owners to pay their fair share. If enacted, HB 178 is likely to have significant unintended consequences and a chilling effect on the condominium market. Specifically, if a condominium board can foreclose upon a unit, it will increase the lenders or members' risk associated with condominium lending. This could also result in borrowers paying higher interest rates in an already high interest rate environment to account for the added risk or limit access to lending more generally. Such consequences are likely to have impact that extend beyond the banking industry and could make condominiums a less attractive option for first-time home buyers, which may reduce the values of condominiums and could impair an already anemic housing market by taking options off the table. There's also a substantial question as to whether this bill runs afoul of Fannie Mae's eligibility requirements. Since 2014, Fannie Mae only requires a priority lien for 6 months of unpaid assessment fees. Under this proposal and others like it, the lien holders would be entitled to legal fees, costs, and expenses. Why would this impact banks? Many sell their mortgages to the secondary market while still maintaining the servicing rights. Fannie Mae is one of the entities banks use in the secondary market. Adding these fees to the lien would likely prevent this from occurring, making condominiums mortgages riskier for banks to take on, possibly adding to the chilling effect this bill will have on the market. I'm going to just address a couple questions that were raised to the prior speaker, Representative Gibbs. You made actually a great point in the fact that a condominium association, this would allow them to foreclose on initiate the foreclosure for a few $1,000s as opposed to the bank's risk that could be $200,000 in your association's case, if not higher. Also, as far as the maintenance of the abandoned property, Fannie Mae does have a property maintenance matrix for the if a bank has identified a facility as being abandoned, a mortgaged property as being abandoned or vacant. So there's certain things they have to do. I'm happy to provide that matrix to you all if you'd like. So in closing, and before I hand it over to Rob Deal, who would like to share a few thoughts of his own, in closing, I would respectively ask the committee to vote down HB 178 and recommend an expedient to legislate, as the committee has done in the past with similar bills. Thank you for your consideration, and I'll hand it over to Rob.
Good morning, committee members. I'm Rob Deedle. I'm with the Gallagher, Callahan, and Gartrell firm here in Concord, and I'm counsel to the Bankers Association. As Ryan said, this is an issue that's been bubbling up off and on for years. A great and workable compromise was reached in 2010. And I thought I'd share some perspective. There was a case back in 2016 that went up to the New Hampshire Supreme Court, which I had the privilege of representing the Bankers Association in. And it's called New Hampshire Housing Finance Authority versus Pinewood Pinewood Condominium Association. What happened in that case was the condominium association sought to impose lien rights against actually the New Hampshire Housing Finance Authority's interest. This isn't always in the context of banks. It can impact anybody that holds a mortgage. And the Superior Court read our Condominium Act, thought that priority rights could be obtained, and New Hampshire Housing Finance Authority appealed, and we joined in that appeal. The New Hampshire Supreme Court looked at our Condominium Act, looked at the compromise that was put in place in 2010, and found that the 6-month priority lien that exists under state law represented a very careful balancing that's necessary to ensure that there's access to credit for individuals who want to buy condominiums in the state of New Hampshire. And I want to flag at the end of their decision, and they don't always do this, they included sort of a discussion about the policy reasons here. And Justice Bassett wrote, "Our holding today advances the policies underlying the Condominium Act. To rule otherwise, meaning to allow more than 6 months priority, would create uncertainty for lenders that provide mortgage financing to condominium owners. The ability of condominium owners to readily secure mortgage financing is crucial to the viability of the condominium form of ownership. Improving access to mortgages for condominiums allows those who cannot afford a single-family dwelling to realize the American dream of homeownership." This policy principle that they outline is not hyperbolic in any way. The standards that Ryan mentioned from Fannie Mae really come into play here. Because when a bank originates a mortgage loan, they're frequently doing so with the understanding that they're going to pass that debt on to a secondary purchaser of that mortgage. And if Fannie Mae is not standing behind that, then that mortgage is not going to get sold on the secondary market. And as a consequence, there's a trickle-down effect. Then the bank won't be in the business of issuing condominium loans. There's a real-world problem with that has a meaningful impact. And Representative Gibbs's comment about the disparity between the amount that might be owed and the amount owed on the mortgage is an important one to really highlight, because it's actually worse than what Representative Gibbs said. Under this bill, it provides, and this is at line 17, the reasonable legal fees and costs incurred by the Unit Owners Association shall be included as part of the lien and part of the priority lien. So if we pull back and think about, practically speaking, what could happen here, you could have a condominium board that's frustrated with a unit owner, wants to get them out, wants to foreclose, is owed a couple $1,000s, and goes into court, hires an attorney, and the attorney says to the board, there's no skin off your back. I'm going to be able to collect my attorney's fees against the mortgage. And then they go into court and they potentially foreclose for $2,000, maybe rack up tens of thousands in legal fees, and then all of that comes out from a priority position against the bank. That is a real problem, and there's no checks and balances right now in this bill as drafted to prevent that type of scenario from occurring. So I hope that information is helpful. If there's any questions, I'm happy to take them.
And Rob,
Evidently, he had lots of questions. Representative Speeder.
I'm not a banker and I'm not a lawyer. So I may not see the nuances of something, but if we did change the words the way the sponsor indicated and said this can only happen in the case of an abandonment, we're not talking about foreclosing for $2,000 in fees. We're talking about a condo that's been abandoned, and the association now says, all right, we've carried this long enough, and a definition of what long enough and abandonment is needs to be defined. Does that ease up any of this?
You want to take it? You want to? Sure. Okay. Potentially. And I say potentially because the devil's in the details, right?
Certainly.
There'd have to be meaningful safeguards in place to make sure that the proper parties are being noticed. There'd have to be evaluation from my perspective on the timelines and the amounts that would trigger this sort of event to occur. But there would also have to be thought given to this priority position, the language that's in there, because it encourages the tail wagging the dog, so to speak, right? And so long as the condo association can get priority of both more than 6 months, attorney's fees, all of that, you're going to be stuck with the same problem that the secondary market might not accept these loans. And beyond that, you may have a scenario where a small amount grows into a large amount through attorney's fees and really creates an inequitable balance. So it's doable, but there's a lot along the way.
Okay.
Mr. Chairman. Thank you, gentlemen. So, with respect to the issue of the condo association not being happy because it's not receiving its fees, would a situation exist such that the lender would not be receiving or would be receiving payments at that time? Such that the lender would be disinclined to move to foreclose because the lender was actually receiving, shall we say, mortgage payments? And in general, what are the factors that would lead you to foreclose or not foreclose, in addition to the illustration which has already been cited, where a condo unit may actually be appraised at a value less than the original mortgage amount? I hope that those two questions are distinct enough so you can answer both of them.
Yeah, I
Thank
think I
you.
can. Well, there could be a variety of reasons why the bank's not foreclosing. I think one would be that they're trying to work something out with the home buyer. You know, maybe providing some loan modification to get them through. The last thing a bank wants to do is foreclose. It's really the last tool in the toolbox, because again, there's a lot at stake here. It's a high risk. They don't want to. They want to keep that individual in their home. I think we saw that through the COVID pandemic and all the forbearance programs that were going on to really make sure that homeowner, again, a lot that was required, but banks were doing that prior. It's what they do. They want to make sure that the mortgagee is in their home and trying to work through it. Rob, I don't know if you have anything else you'd like to add.
No,
With
think
respect to
that's
the
a-
first question, please. Yes.
Yeah, I think that's a fair summary, Ryan. As Ryan said, there's a lot of reasons why a bank might not be foreclosing. One of the principal reasons might be that they may not even be aware that there are delinquencies outstanding in the condominium assessments. And this goes back to the policy issues we were talking about before. Part of the reason why 6 months priority lien rights were created to give condominium associations that right is it reflects an understanding that condominium boards are in the best position to understand if there's a problem with a unit owner, if they're becoming delinquent. Banks are not always going to be aware of what's going on, boots on the ground at the condominium association. And that dovetails into, it's not just a priority lien right that was created. As Ryan mentioned in his remarks, there's a right to escrow condominium association dues. So these things are intended to work in concert with each other. So if you're a board and you've got an individual who you're foreseeing a problem, you can go to them and say, look, we've had some issues with your payments. We want you to escrow 6 months worth of condominium assessments. But what's happened, and this is just a practical observation. So I'm a practicing lawyer. I'm often defending individuals and companies in court. I've had condo associations call me up and they'll say, we've got a delinquent owner. What do we do? And I'll ask them, well, did you put in place the 6 month priority lien? And almost always the answer is no. And it's not because that lien right isn't working. It's because of the realities of a condominium association. You have volunteer boards and you have, most condo associations are small. They're not 100 units. They're 20 or 10 units. And you know the people personally and individually. And I think there's a human nature aspect of perhaps not wanting to be aggressive and going after them. But those are decisions that are being made by the condo association that the bank can't control or be a part of in any meaningful way. So I hope that's helpful.
Further question?
Follow, thank you. So in fact, there are situations where condo owners are making their mortgage payments, but not paying their condo fees which is what I think I heard when you said we're not even aware of there being a problem. And I infer from that that you're saying that the bank is being paid, and it turns out that at the same time, the condo owner is not paying his or her condo fees. Is yes or no?
In some scenarios, yes. In some scenarios, no. And what's more nuanced than that is that sometimes these disputes, the reason why they're not being paid is not a financial reason. Sometimes it's, we don't think that contract with the guy who mows the lawn was a good contract and the board is mismanaging it. There's a lot of personality and human nature that comes into these
Thank you.
situations.
Representative McVeigh.
My question to the previous speaker was whether the bank can or will pay, the electric bill, the fuel bill, and whatever. And you mentioned the Fannie Mae matrix. So do I understand that that's required in order to sell that mortgage into the secondary market? Could you explain a little bit further?
So, generally, what happens is when the bank makes the mortgage, and they sell it off to the secondary market, they still own the servicing. They'll maintain the servicing rights. So they bill the customer, and when the bank, under the agreement with Fannie Mae as a servicer, when they've identified that the property is vacant and abandoned, they have this obligation to maintain this property through this property maintenance guide.
Thank you very much.
You're very welcome.
Great. Thank you very much. Oh, yes, Representative Sullivan.
Thank you, Mr. Chairman. One of the things that you mentioned is the potential for a trickle-down chilling effect on the condo market. I'm curious, since there are other states that have similar types of laws, if we see any evidence of that actually happening. Seems like a perfect natural experiment between Massachusetts and here to see if there's a big delta between single-family homes and condos in Massachusetts that doesn't exist in New Hampshire because of the regulation.
Well, what I would say, and Ryan, certainly step in if you have more timely information than I do, is unfortunately I don't know the specific answer to that question, and I'm not sure it actually is answerable. And the reason why I say that is because these condo acts are fitting within the matrix of whatever the laws are in place. So, for instance, New Hampshire foreclosures are generally not judicial foreclosures. They're power of sale foreclosures. Another jurisdiction might have a judicial foreclosure system. They might have different mechanisms that enable condo associations to be more proactive or not. And beyond that, Fannie Mae has standards that are time-based. So if laws were enacted prior to 2014, Fannie Mae will recognize those. If they're enacted after 2014, they do not. That goes down to reasons of notice and takings and things along those lines. But it's very hard to compare apples to apples in that scenario.
Yeah, my memory was when we did this bill 12 years ago. Maybe I'm going to ask Tara Reardon whether she remembers. So I remember we did get a piece of paper that said the Massachusetts interest rates were 3/4 higher.
That
I
may
remember
very
getting
well
it
be the
back then.
case.
But- So, anyway, thank you very much.
And I do have testimony that written testimony that I'll hand out.
Good. That'll make the clerk happy. Okay, Eric Shaughnessy. Good morning.
Do I need to hit this button? Yes, of course.
Red is good.
Thank you. Red means stop, I thought. Good morning. My name is Eric Shaughnessy. I'm an attorney. I represent condo associations in New Hampshire and in Massachusetts, and I'm speaking in support of this bill. I'm also a member of Community Association Institute of New England, CAI. There's another member from that group that will be speaking. So I'm going to leave some things to him, and I'm going to be addressing some things from what I've heard. And I want to start by actually doing a little comparison, because there were some questions asked about other states and how they operate. And I'm just going to highlight, it's our neighbor, Massachusetts. They have a priority lien that can be any number of months, not 6, not 12, not 18. It can in theory be any number of months. And they have the ability to foreclose. And we see no chilling effect on sales of condo units throughout the state. So from a practitioner standpoint, we see no problem in terms of units being sold all the time. And the fact that Massachusetts can have 6, 12, 18 months of priority lien has not stopped the secondary market from happening. And the representatives from on the banking side, you'd like to use terms such as likely and maybe, very non-definitive terms to suggest that there could be, in theory, a possible issue. And I just want to highlight that. We see, as from a practitioner standpoint, actual problems within these communities where you have unit owners who, for whatever reason, choose not to issue payment of the condo fees, which then places the financial burden on the remainder of the community to carry that and to carry it for an extended period of time. That is inherently unfair to the rest of the community. This bill is simply seeking to create a uniform mechanism to solve that problem. It does not create more than 6 months worth of priority lien. It's still 6 months. If there's a priority lien, you have the right to foreclose. If there's no priority lien, you still have the right to foreclose. But it doesn't go from 6 months to 18 months or from 6 to 12. It stays at 6. That number doesn't change throughout the course of this process. And in terms of the safeguards that were mentioned, talked about it in the form of notices. For a practitioner, such as myself, to go to get this priority in theory to foreclose, we have to send notice to the owner. We have to send multiple notices to the mortgage company. We have to file a lawsuit. We have to serve that lawsuit on the unit owner and the mortgage company. We then have to file all the paperwork with the court, serve that paperwork, including motions for judgment on all the parties, then hold a hearing where the other side, the bank, the unit owner, has the opportunity to be heard in court. And then the court, the judge, will have to rule on the issue and grant judgment and allow the association to move forward. So this isn't as if we send one piece of paper out the door and all of a sudden we can go foreclose. There's an extended, long process to get to the end point, wherein many of these safeguards mentioned are hit. Repeated notices throughout the entirety of the process. When the bankers say, well, we don't know what's happening, we let them know multiple times and giving them multiple opportunities to address the issue, which they have the right to do. And they have to make a decision, either to address it or not to address it. It's not a lack of notice or lack of being informed. It's an internal decision whether they address it and respond. So with that, I'm happy to take some questions that may exist, but that is the process. It is not overnight. It is long. It is slow. And this bill seeks to create a unified process to address really those habitual non-payers.
Representative Sullivan.
Thank you, Mr. Chairman. So I'll ask a similar question I asked them. Because you mentioned it, you seem to think that there is no chilling effect in the secondary market in Massachusetts. Are you saying that because people are able to do it, or are you saying that there is no spread between maybe what's happening in New Hampshire and here, or what's happening in single family versus here?
What I can say is, from my perspective and what I see no issue, no problem in mortgages being assigned. Because we look in the registry of deeds, we follow the title to the property when we do this. We see it all assigned all the time. We deal with servicers all the time. From my perspective, from what I see, I do not see, and I'm not a lender, so I can't speak on their behalf, but I do not see anything that indicates that there's an inability.
Follow up?
Further question, you may inquire.
Okay, but to be clear, you're not sure if there is a larger spread in the condo to single family market in, say, Massachusetts, which has this law, versus, say, in New Hampshire, or if you were to compare those two spreads in the two states. Like, there's ways to get at this. I'm just wondering if you know that.
I personally do not know that, and I cannot say definitively.
Okay, thank you.
Representative Herbert, did you have a question?
I think you might have just answered the question I wanted. You represent Mass and also New Hampshire.
Yes.
Is there any distinction or difference in the system in New Hampshire that informs you because you were talking about Massachusetts most of the time?
I'm talking about both states. So right now in Massachusetts, so we understand it, to effectuate a priority lien, we have to send a series of notices to the unit owner and to the mortgage company. And in that sense, it's exactly the same as New Hampshire. Those processes are pretty identical. From that point in Massachusetts, we file a lawsuit, we serve it on the parties, and we seek judgment. We go to court. The court grants the judgment possibly, and from there we're allowed to foreclose. And in Massachusetts, we're allowed to add more than 6 months. New Hampshire right now, we send those same notices. We then record what's called a memorandum of lien, and then we can file the lawsuit. And from there, we can go to court, get a judgment, and then from that, we can exercise a sheriff's sale or some other mechanism to try to get to the end goal, which is a more prolonged process. So I guess to answer your question, I'm not just talking about Massachusetts. There's the states that have a big distinction, and there's a huge separation at the point following the notices being sent.
I guess my question, just one
Question?
follow-up. So my question is essentially, is there a problem, in your opinion, between what New Hampshire has now, or if they put a 6-month limit, is there a problem or an issue there that would tell me as a legislator, this is not a good idea, something else should be done? Because Massachusetts has multiple, I'm trying to figure out whether we should be doing anything, and I want your opinion.
Sure. Yes, my opinion is there is a problem. There's an inability for these communities to resolve perpetual non-payment, historical non-payers, that you'll have literally years of condo fees owed because there's no good solution in the pocket for the association. The idea of getting 6 months paid up front doesn't make sense when the owner's not going to pay already. We can't say, please pay us 6 more months if they're not going to pay us the existing 6 months. So there is a problem that this bill seeks to solve, which is addressing the habitual non-payer and thus stopping the burden being picked up by the rest of the community.
Thank you.
Yes, Representative.
The sponsor, when he spoke, said that the attorney could address some of the questions about the imbalance between the
That's a
unpaid-
different attorney. I'm sorry. Yeah, that's somebody else that he wants. But go ahead, ask your question. But
My apologies.
I screwed up.
But
forgot to-
perhaps nevertheless, you can help answer this question. Back to the imbalance that I referenced in my question to the sponsor. There's been some discussion about the limitation of the unpaid fees lien to 6 months as being an advantage in the mortgage market. And I can see where that could be true. But the result is still that again, assuming that this bill isn't changed so that it applies only to really abandoned units where everybody, including the owner who's away in Iraq or wherever it might be, would have notice. That the $200,000 unit would be lost, and I'm not talking about the loss to the bank, and I'm not talking about windfall profit. I'm talking about someone coming home from, say, a long-term military deployment or a long-term hospitalization, and discovering that they have lost their home, which is worth $200,000 because of $2,000 in unpaid condo fees. Can you address that issue?
Sure, I'll do my best. I'm not aware of any situation like that ever occurring. There are safeguards for people in the military where we don't have the right to foreclose on them, which would apply in this case, I believe. And we also have an obligation to serve individuals, right? We have to go to court and we have to effectuate proper good service of the complaint upon the individuals. And if we cannot do that, if we cannot make the person and individuals aware of the lawsuit that's pending, we have no right to judgment in the courts. So there are safeguards in place where that outcome should never transpire.
One further inquiry?
Okay.
Thank you. Would you see a problem in including a change to this bill, providing either a minimum dollar amount or a minimum percentage of the value of the unit in unpaid condo fees before foreclosure and sale would be an available option.
Yes, I see a problem in that because it really restricts the effectiveness of this. If you have a unit that's worth $1 million and the condo fees for this association are $250, how many years do we have to get before we hit that threshold? How many years does the rest of the community have to carry the burden for the remainder of the owners? So I do have a problem with that. I think practically speaking, we don't see that issue. I just don't see it's how best to put it. But by, I guess, creating a percentage or minimum dollar amount, we're ignoring what the condo fees are per month, per se, because you have some communities with higher fees and some with lower fees, and the value is the same, right? You could have a condo unit that's worth $200,000 and the condo fees are $100 a month, and you have one where the condo fees are $500 a month. The valuation doesn't change. And why should the rights be different under those two circumstances? I think a more uniform process makes the most sense.
Great, thank you very much.
Thank you.
All right, sorry, Gary, you get shuffled down. Yes, come on up. So Gary Daddario, which represents CAI.
Hi, good morning. As the chairman mentioned, my name is Gary Daddario. I'm also a condominium attorney. I'm a partner at the law firm of Marcus Rico, Emmer and Brooks. We represent associations in several states throughout New England. I'm going to start by addressing what I'll call the deja vu issue. Yes, we've been here before with this bill. Yes, it hasn't passed to date. The reason why we're back isn't because we like doing this. It's not because we are willing to waste our time. It's not because we want to waste your time. It's because the need is still there for these associations. And if anything, as the years march on, that need for this law to be in place is increasing. And that's why we're here. Along those lines, I will tell you that I have been focusing my practice in condominium and association law for the past 20 years. And what I'm seeing lately are things that I've never seen before. I'm seeing associations where their year-end financials, year-end, no more movement, no more play, are showing that they have operated at a deficit for the year. Simple mathematics tells us associations can't do that indefinitely. They need to be able to pay their bills. And as you've heard, a lot of this might be utilities. It might be the heat that's keeping the pipes from freezing in the winter, but it's also the insurance on the property. And as I think most of you know, the insurance company's not going to have a problem canceling that policy if the premiums aren't paid. So the idea that associations don't have enough money to pay their bills is a serious problem. And it's a serious problem for everyone, including the lenders. I would point out to this committee that you have in the existing law of this state a budget process and a special assessment process that allow communities by a 2/3 vote to reject what is proposed by their board. So understand, please, that when an association is operating at a deficit under the law, it's not even as simple as board saying, we have a shortfall. Unfortunately, we're going to have to make another assessment to catch up on our money. Because if they try to do that, the community can simply show up and say, thanks, but no thanks. We don't want another assessment. And now the assessment is rejected. So boards are being put, between a rock and a hard place, to use a cliche expression. And they really need some assistance here. You've heard a lot about the inequities that result when some folks are paying in the community and some folks are not. I'm going to use some harsher terminology. I think what you have in those instances is you have forced private subsidized housing. Because if I'm paying my condo fees and any one of you are my neighbors, you might be right on the other side of the wall and you're not paying your condo fees, and this is going on for years at a time, I and the other owners who are paying the condo fees are, make no mistake about it, we are subsidizing your life and your investment in this piece of real estate. And it's not fair when you consider that these are all private parties, and the point of the association is to be sharing in the expenses. So again, there's a very real problem that needs to be solved for the benefit of all who are there. You've heard that there are possible negative consequences to the market. There's been a fair amount of discussion of that. I'd like to add some information for you in that respect. CAI, on behalf of which I'm speaking today, and those letters, by the way, stand for the Community Associations Institute. They're a nationwide nonprofit whose existence is solely to make association living better. That's the only thing they ever try to do. That's why they exist. Because they operate on a national basis, they keep tabs on everything on a national basis. Just so that you're aware, there are 21 states and 2, we'll say districts, who have priority liens. Of all of them, any association in any of those places, with the sole exception of New Hampshire, can foreclose on their priority lien. So to be clear again, what you have in terms of, does it work? Does it break down the market? If we do this, is there going to be a problem? Is there a problem elsewhere? In response to all of those questions, know that there are 20 states that allow associations a priority lien and the ability to foreclose on it. That is also true of the District of Columbia. It is also true of Puerto Rico. New Hampshire is the only state that has a priority lien where we are still trying to be able to have the association have a right under the law to foreclose on that lien. Now, you've also heard some testimony and asked some questions about the process and the concerns of the process. Is it going to happen too fast? Is it going to happen for too little money? Is it going to prejudice anybody who doesn't know about it? And I would say to you that the answers to those questions are no. Again, under existing law, associations are filing their lien, they're perfecting their priority lien with 6 months owed. So no one's foreclosing on 3 months, no one's even foreclosing on 6 months, because at the 6-month marker, they are filing their priority lien and recording their memorandum of lien with the Registry of Deeds. So now 6 months are owed. What happens next? Next, if the association isn't paid, then they file their lawsuit. When the lawsuit's filed, there's a 3-month period to achieve service of process. That's where we get into the issues of, has the lender received their service of process? By the way, the lender is entitled to not 1, but 2 notices prior to the filing of the suit. So again, the lender is going to be keenly aware of the situation. 2 notices prior to suit, then suit is filed. Now we're at the 6-month mark. Now there's 3 months for service of process, during which time the lender is being served, the unit owner is being served. Here's where we get into concerns about military and so on. Someone who's deployed in the military, we're not going to achieve service of process on them. And as Attorney Shaughnessy mentioned to you, then the suit is going to stop, because the court doesn't go forward when you don't have service of process on the defendant. But let's assume that service is made. At that point, the defendant has a month, give or take, to answer to the complaint. After that month goes by, and if an answer is filed, now we get into motions that get filed in the case, whether they be for judgment or otherwise. As was mentioned to you, a hearing needs to be scheduled. That gets scheduled, according to the court. And unfortunately, most attorneys will tell you that, we wish hearings would come sooner than they do, but the courts are busy, so it takes time. After the hearing, there's some time that passes while the court decides what they want to do with the case before they issue the judgment. When they do issue the judgment, Again, the defendant has a month, give or take, to make payment on that judgment before anybody can try to further the process. So to be clear, when we're talking about foreclosure in a condominium case, we're not talking about $2,000 for 6 months of condo fees. That was when the lien was filed. Then we got into the lawsuit, then service of process, then the litigation, then the time for the hearing, then the judgment, and so on. Foreclosure hasn't happened. In the 20 years that I've been practicing, I don't think I've ever seen a condominium unit go to foreclosure in this state or in Massachusetts, where I also practice. I don't think I've seen a unit go to foreclosure, or in this case, sheriff's sale in New Hampshire, in less than a year's time. And usually it's more than that. To address for you the concerns about legal fees, again, I can only speak for myself. I can't speak for all attorneys, but tens of thousands of attorney fees for the association in these cases, no, not for me ever. In 20 years, I've never had fees of tens of thousands of dollars, even to foreclose on a unit if the case ever goes that far. And by the way, keeping stats on my practice as I do, in that 20 years time, less than 3% in the jurisdiction where I could foreclose, where the association has the right to foreclose on a unit, less than 3% of all of my cases ever reach that point. Why is that? Well, for one thing, when you can foreclose, now you have the ability to say, this case is going to end one way or the other. And guess what? Some of those unit owners, when they're faced with that situation, will do what they need to do to pay the association. Maybe it means taking out a loan or another mortgage. Maybe it means, you know, in the worst cases, that they allow something else to fall a little behind because the day has come to pay the association if things are tight, but they make something happen. Alternatively, the bank, the lender in the situation, can make something happen. Not the least of which, by the way, is that they have the right, and by the way, that's why they get the notices in the first place, they have the right to make payments of the assessments. And in the standard condominium rider that goes with the mortgages that they issue when folks are buying these units, it allows them, if they have to pay the association the condo fees on the unit owner's behalf, it allows them to add that to the balance of the mortgage. So ultimately that money is collectible for them in the end. The bank isn't paying it out of their pocket. They're paying it as part of the debt of the unit owner. They have that option. Speaking of options of the bank or lender, as the case may be, I would like to note that they have options at the beginning, options that never exist for the association, meaning that they pass judgment on the applications that they receive. They have the ability to look over an application and say, we are approving this loan, which I assume they do when they feel confident that they will be paid back. But conversely, if they decide that they don't want to give that loan, they simply reject that loan. The association, on the other hand, regardless of what association we might be talking about, when a unit owner buys a unit, that's it. No judgment call. They're a member of the association now, and the association is forced to deal with them. And if there's someone who doesn't pay their bills, then the association ends up with a problem, potentially a long-term problem. And, you know, this foreclosure remedy, as you've heard before, I can tell you, for all of the associations I represent, it would be a last effort measure that you would undertake in a case that just didn't resolve by any other means. That's what it is. You heard about the association's other remedies. They will try those. Sometimes, you know, the balance is paid because a lien gets recorded on the unit. And if that balance is paid, then that's great. Then the case ends. Sometimes they're paid because a judgment issued from the court. If so, that's great. Then the case ends. You heard about ceasing services to delinquent unit owners. The law does, in New Hampshire, afford associations that right. However, in the worst of these cases, the unit owners are not even at these units. They've either abandoned them or they live elsewhere because this was investment property. They may even have tenants in these units. The point is, if they've decided to be a long-term delinquent, and if they're not on the property, and the association says, no more access to the pool for you, they simply do not care. And in the cases where They're refusing to pay. A court judgment doesn't make them pay. Denying them access to the pool isn't fruitful. Time has gone on. You're now over a year. You might be at 2 years. Then a really big question arises. And it's a difficult conversation for me every single time when my clients say to me, how are we going to end this? And unfortunately, under New Hampshire law right now, there isn't a good way to bring any finality to the situation. And I would suggest to you that by allowing associations to foreclose at the end of a legal process where everyone has notice, it just isn't unfair. It just isn't. What it is it's fair to everyone else in the association who is trying to meet those responsibilities, the financial obligations that they all have. I will stop there. I know we're having issues with time, and I want to make sure that there can be questions if there are any.
I think they're all questioned out. Thank you.
Okay, thank you.
Got one more card left. Lee Greenwood.
Good morning, Mr. Chairman, members of the committee. My name is Lee Greenwood. I represent Associa. Associa is the largest national association management company in the country. We represent managed condo associations, HOAs, etc. We have been active in New Hampshire for over 4 decades now. We're a large presence here. We manage over, make sure I get these stats right, about 25,000 units. We have about 150 employees in the Granite State. So we've worked here for a while, and Gary stole a lot of my thunder, so I'm going to be brief, I promise you all, and did it much better than I ever could.
Appreciate it.
Yes, of course. But honestly, what this bill comes down to me is 2 words: equity and fairness. Words that we hear a lot today around us. And when I say that, I mean in a couple of ways. But the main way is that, as Gary sort of alluded to, an association is a community, right? And that community is made up of individual unit owners that have entered into a contract with the association. So every time they buy into that association, they sign a contract agreeing to pay their assessments. Now, the board of the association, of course, creates a budget, pays fees, insurance, maintenance, the pool if there is one, etc. And all of those fees, as for all of us, have to be paid for somehow. So in the cases where there is a delinquent owner, those fees don't just get absorbed into the air. They have to be made up one way or the other. And the way that they're made up is that the other unit owners have to pay more. And that, to me, and I think to a lot of us, is just an unfair, inequitable way of dealing with the situation. If 99% of the people are paying every month as they're supposed to and as they're contractually obligated to, but 1% isn't, that's not fair for the 99%. And as Gary said, foreclosure is, of course, a last resort, as it is in the 20 other states that have super lien priority. And also the Washington, D.C. and Puerto Rico. So it really does come down to that fairness issue. And then I just want to very briefly mention, our friends in the banking community mentioned that the numbers that we're talking about when we're talking about missed assessments or delinquent assessments certainly typically dwarf compared to what a mortgage holder would have. But, let's think about that in scale. The numbers, while it might be a few thousand dollars to an association really is the difference between running your association or not being able to pay your bills. So yes, it might be a larger number in some other kind of liens, but in an association where you have as few as a handful of unit owners or as many as, a couple of hundred, that really, those numbers do add up very quickly. And as far as the chilling effect concerns, I would just say that as Gary said, in 20 other states, in DC and Puerto Rico, the condo market is robust. People are buying and selling their condos. I mean, I am one of them. I live in Massachusetts. Sorry about that, but I live in Massachusetts and I'm a condo owner, and I can say that the market is robust. I don't have the data, but I certainly know that those markets are flourishing and those associations are doing well. So I will leave it there, but I just did want to leave one other thing with you all, that then these numbers were kind of shocking to me when I first saw them, but as of about a year and a half ago, there are 267,000 New Hampshire residents who live in an association of one form or another, an HOA, a condo, and that's roughly 20% of the folks living in New Hampshire, the population of New Hampshire. So this is a housing model that is growing, that people are happy in, and that you know, a large number of New Hampshire residents have chosen to buy into. So this is an important bill for us. We certainly would urge the committee to support it and report it out.
Great. Representative Fieldwood has a question.
Thank you, Mr. Chairman. Just a question that was actually raised to me from your colleague. Some of these units will be investment properties in which you actually have tenants who are not the ones who are directly paying the mortgage. How would this law and the eviction mechanism in this law interact with federal law, such as the Protection of Tenants at Eviction Act? And how do these two overlay, as you've seen in other states with this type of provision?
So I'm not really sure the answer to that, to be honest with you. I think I would ask one of our attorney friends. Do you have an answer that you can?
I'm sorry, I just walked back.
Oh, sorry.
I don't know.
The question was, so how would this type of provision overlay with federal protections for tenants who are living in an investment property, such as the Federal Protection of Tenants at Eviction Act? And is there an interaction between this type of provision and federal law?
Tell you what, why don't you think about the answer for that one, and then send an email to the committee to respond to it.
We'll definitely do
But so at least when we take it up by the subcommittee, we'll hopefully get an answer to that question.
Sure. Short answer for now, I don't think there is a formal interplay, because I think what we're talking about are relatively new provisions. And by the way, obviously my bias is towards associations that I spend my career trying to help, but all of these new provisions, you know, while I'm not looking for people to be thrown out on the street, that's not my thing. But to the extent that the federal laws prevent that from happening, the associations who aren't getting paid just sort of suffer right along.
Yeah. Unfortunately, you don't have a mic, and so we'll just have to. Well, wait. Send us an email. Thank you.
Do you have written testimony, any of you guys?
I submitted my written testimony to the clerk this morning, so.
Okay, great.
Okay, great. Thank you very much.
Thank you.
All right, having no more cards, I apologize, Representative Almy. We'll close this public hearing and open up the next one. And House Bill 239. Good morning, Representative Almy. Yeah. Hey, John. Lucy. Thank you.
Okay, I'm Representative Susan Almy, City of Lebanon, Grafton 17. It's hard to remember the number. And I've been I started the condominium committee, and I've been on it all but one term since then. So you may be seeing me again. In fact, next year for sure you will be seeing me again with the bill that we keep trying to get passed. But I'm here today on behalf of a man who lives in Massachusetts and has a condominium in Lincoln. And he is a representative of the very large group of second homeowners in condominiums in our state. And they do pay property tax. And he has pointed out to me something that I hadn't thought about before. In 2017, Representative Webb brought in a bill which said, I can't manage to get details about the budget and what's going on in my condominium association. I want you to change the law. And you and my committee, to some extent, also statutory committee, worked on the language some, and we came up with what is was in HB 502 as it was enacted. And that is the first 3 pages that you're looking at. For some reason, the copiers decided to put my testimony on the back. He pointed out to me that there is nothing in the law that requires a condominium to produce any kind of a review or audit of the finances and hand them to the members. There is in some bylaws, including in his, but his condominium has been creative about of reinterpreting the bylaws as well as the law that we produced in 2017. So it's too easy in the condominium world for boards or their property managers to hide problems in the finances of their operation, particularly when most of the owners are second homeowners and not present. The legislature took this stab at it in 2017. Condo owners should be able to get sufficient information to know whether their investment, and for many of them their residence, is in trouble. When it isn't, which is usually the case, that's fine. When there is a case of mismanagement or worse, the owner has the documentary proof that can form a group to demand changes, to take over the board, to correct the problem, or to go to court equipped to prove the case. And you have seen some of those come here to testify in past terms. And I have seen more of them. There was another board in Plymouth, which without any information to their members, got a loan from the local bank to pay for overages in their expenses, which were above special assessments that they'd done that they then used for other purposes. And they gave the bank total control over the checkbook of the condominium association. The bank was receiving the deposits, and the bank was okaying the expenses. And this was totally unknown to the people in the condominium, most of whom were second homeowners. And I was contacted by a woman and spent the summer going through the Grafton Registry of Deeds to find these bank contracts that they knew nothing about, which then helped that woman to get the second homeowners together to confront the board and get this solved. So this kind of thing does happen. I hope it's rare. We found out a fair number of them in those of us that have been on the condo board for more than, condo committee for more than a term, because people come to us. But then people either decide that they can't handle this and they're selling out and they're leaving New Hampshire, or they come to us and we kind of participate with them as they solve the problem, and then they don't come back to talk to you about it again after the first 2 years. So it does take years of mismanagement sometimes for for the owners to begin to recognize that there's something wrong with their investment. But it would be much better to do a real independent audit every year or every few years to reassure the owners. We do not now require any kind of independent audit, whether the kind my complex does by hiring an independent accountant actually to check our bank statements against our bills, or the very thorough kind that Mr. Bob Simic behind me is proposing. His small association is run through the board by an external manager who audits himself and then says everything's fine. Mr. Simic has spent years trying to use our section 37E 2 to demand an independent and thorough examination of the books. The board has denied him. He has hired a lawyer and a CPA to help him. I bring you this bill because I think that it seems likely it would make it easier to get this audit or to convince a court to requirement with language that more closely follows the auditing process. The bill builds on the 2017 law. It expands on the second section. The first part, which we've relabeled Roman 2A, treats the information specified in 2017 as a subset of all the relevant financial data that should be made available to an inquiring member. Right now, it talks about contracts, mortgages, debts, long-term commitments, and that has been very important in some cases that I've dealt with before, but it does not talk about the current accounts of the association and the bank statements, which can give you an idea if there's something strange going on in the finances. Section Roman 2B adds a requirement that every condominium board should be providing the members with an independent review of all books and records at least once every 3 years. This is purposely vague enough that it could be done at minor expense. In my association, we've got 22 owners. It's done annually for $300, just checking the bank statements against the billing. And it goes on to say that any owner or owners at their own expense will have access to do a more detailed audit, as long as such an audit has not been done within the last 3 years. So it protects from the kind of member who wants every single detail of the association's life for every single month, which I experienced early in my time in condominiums. But it does say that once every 3 years, if a member or their members think that there is something strange going on, can get a real audit, but they'll have to pay for it. Roman 3C, 2C keeps the second part of the original language about privacy of individual owners' accounts, but adds that the auditor with adequate privacy protection should be able to see those accounts. I had one case recently where a woman was in a 4-person condominium, and when she moved in, after she moved in, she realized that she was paying a lot more than any of the other 3 people. And that 2 of the people had been put in there specifically by the owner for that purpose. So this is, I'd just like to end there, but ask you to call on Mr. Simic next, and then the others, so that he can explain better than I can about what he's looking for. Thank you.
Oh, yes, Representative Spear.
I'm not understanding the difference between 2A. Oh, I just lost it. Sorry. 2A and the paragraph after that, and 2B. So 2B is saying that, you know, every 3 years we can have an audit. And if you want additional details, you know, you would pay for that. 2A is kind of indicating that they have access to all kinds of things. Are you saying that an owner can ask the condo association to start printing out reams of information that on a whim just because they want it?
I experienced this when I was first in a condo association after I came back to this country. And it was a neighbor, a new neighbor of mine. And yes, he was insisting on printouts. This does not mention printouts. It says access to.
What do you mean by access? Just that you have to make the books available? Or
Yes, that that person can go to your office and check the financial books.
in the case where you talk about owners being out of state,
Mm-hmm. Yes,
And
that
then-
is somewhat of a problem, that when the owners only arrive on weekends. And frankly, I would hope that an owner that cared that much about it could come on a weekday. What has happened with the gentleman behind me is that he set up a time to come and meet. They told him he had an hour. They spent 40 minutes of it with his lawyer arguing about whether they had to do it, and then said, "You've only got 20 minutes left."
okay,
So,
Good.
thank you.
Thank you. Thank you, Representative Almy. Normally, procedurally, we would have a representative who wants to speak, but we'll let Mr. Simic go first.
Good morning and thank you. Appreciate having the opportunity to speak with you all. My name is Bob Simic. I'm a condominium unit owner at the Loonwood Village 2 Condominium Association in Lincoln. That's over on the side of Loon Mountain. I am a small business owner. I run an oncology nutrition business. I'm also the treasurer of a nonprofit organization. This is my first experience in what I'll call managed living. I asked a bunch of questions at my first annual meeting of the board in 2020, and that put me on a certain trajectory, let's say. I will say thank you to Representative Almy, and I'd say overall the new 356B financial disclosure language she's proposing or is being proposed here could be quite beneficial in supporting a single unit owner or small group of unit owners who are struggling to gain access to financial information in their condo association. The first thing I would point out is if you look at the language in 37E2, it starts out quite optimistically saying each unit owner shall have access to all financial information. However, you continue to read the sentence, and it's really specific to contracts, which are debatable, I suppose. I mean, we have a contract with the bank. Does that mean I can get bank statements? It doesn't specifically say I can get bank statements. Why shouldn't I be able to get bank statements? It's my money in the bank account. Mortgages, loans, and terms of loans. We don't have any of those, but great. That's good. Outstanding debts and balances on all accounts held by the association. Well, if you take this literally, like my board of directors and property managers have, that would require them to give me two numbers. One for our operating account and one for our reserve account. That's all we would get from this. Any records supporting expenses that one might want to take a look at, and which my board has always said, the door is open in Campton, New Hampshire. Just come on down and you can look at everything. And then as soon as I said I'm coming, they said not so fast. And then they broke their own rules and said, well, I'll just copy you some stuff, and then I get an incomplete and incorrect copy of whatever. And this has been going on and going on and going on. That's just the beginning of the process, and we don't have time here to go into all the details of it. But I would say as both a condominium owner and the owner of a business, because these are businesses, I would say that unit owners should have more explicit access through this language to the books and records of an of their association. Even after I declared I was going to audit my association in accordance with our bylaws, my board referenced 37E2 and stated they're not required to provide access to the association books, the general ledger, or tax returns. It's absolutely impossible to do a basic financial statement review without access to the general ledger. It was denied me. That was phase 1. Now we're on phase 8 or whatever. I think if I'm looking at 2A, 37E 2A, I think if I were to prioritize some of that, because it was mentioned that there's a whole bunch of stuff in there, I would prioritize bank statements. I would say that from a general awareness, budget tracking, and management point of view, bank statements are probably the best single resource available to unit owners, especially unit owners that are not part of the board. I was told our bank statements would be available in person at the property manager's office, like I mentioned, and that's fine, except the property manager's office is open on weekdays, from 9 to 4:30 or whatever. I live in Dover, Massachusetts. Generally, it's a weekend warrior thing. You go up to the place and you're using it on the weekend. It's not that easy to get there. I took a closer look at that because it wasn't practical for me. So I did the homework. I spoke with the Bank of New Hampshire. That's where we do our banking. And I also spoke with other associations with regards to how to make, just access to bank statements a little bit easier, and found that there's easy ways to satisfy banking privacy laws, and it's easy to truncate and or eliminate account numbers for security purposes, either formally through the bank by having a program through them to do a quote unquote unit owner ready bank statement, or by simply getting out a Sharpie. I offered a bunch of different options to my board. They were all denied. So, if I wanted timely access to my bank statements, I've got to go, from Dover to Campton during the weekday hours, 12 times a year, to get those. I would say in closing, with regards to the bank statements, that, in this day and age when most banking is done via electronic means, including banking at our association, it would seem reasonable to add language that appropriately crafted bank statements, we got to be respectful of privacy laws, et cetera, be made available to unit owners. With regards to association financial audits, I would say that obtaining financial transparency from an entrenched HOA or condo association board can be extremely difficult. The lone unit owner or group of unit owners may encounter significant obstacles in gaining access to financial information. I was quite pleased to find a unit owner audit provision in my bylaws, as Representative Alme mentioned. Although I continue to deal with significant difficulties, costs, and stress, if it was not for that bylaw, I would have been dead in the water. I wouldn't be, maybe not here today. I would say that adding language that allows unit owners the opportunity to conduct their own audits levels the playing field. The board can always do their audit, but the unit owner can't necessarily do theirs. At my association, I can. With that said, and as the language in 2B points out, it uses the word obtaining an independent review. I would say, now having gone through what I've gone through, that true independence and avoidance of conflicts of interest are something to be considered in this regard. My treasurer at one point, after he discovered, and it seemed like the whole board discovered for the first time, that we hadn't been audited in 30 years. The property manager knew that very well and quickly pointed out 6 reasons why we don't need an audit. He decided a few months later to go down to Campton and take a look at the books and records, and reported back at a subsequent board meeting that everything was fine. And I applauded that. I'm like, this is great. I'm just trying to, get some more transparency and visibility into the process and the numbers. So I asked them afterwards, could we speak a little bit about, what you did, what your scope was, just get some idea of what you did. And the answer was one word: no. No. I think the bylaws actually requires them, if he's going to go down there and spend money, and the PM's going to spend money, that he owed us something. But we didn't get it. So, so I would suggest that any language with regards to audits provide for independence. Certainly, you can have an outside accountant, conduct an audit. Often there's relationships with those accountants already, and there's also easily 100 different ways to do audits. Having a board of directors with perhaps inputs from the property manager decide on the type of audit, and then managing the process, delivering the results, is a clear conflict of interest in my mind. Both my board and property manager have been trying to dictate my audit efforts since day one. Uncovering fraud and embezzlement. Well, first of all, fraud and embezzlement is real in this space. It happens. Stone Management being the most recent example down in Waterville Valley. Forensic accounting and a forensic examination of the books is totally different approach, totally different skill set versus doing just a financial statement audit. Both have tremendous value. If the unit owners could be involved in that, and there could be just other inputs, I think there's value in that. Non-board members should have the opportunity to be involved in any audit process. I would go further and say, and this is not in the language as presented, offering the option for associations to assemble an audit committee of non-board unit owners makes sense and removes that obvious conflict of boards auditing themselves. I don't think that should require a vote. I think it should just be there, and they can do it if they want or not. Certainly, any budget allocated for auditing purposes needs to be voted on. I do have a copy of more that I put together that I could provide in terms of my remarks, but that was all that's all I had.
Great.
Thank you.
We do have a question, Representative Burrows.
Yeah, thank you for taking the question. This is a quick one. I'll wait till you come back. That's okay.
Yeah, thanks. Thanks a lot.
Okay, I can talk while you're welcome back. My question is simple. Do you have any insight as to why you're being stonewalled by your association on this? I'm just curious why they're doing this.
At first, I thought they just didn't like me, and I don't think they do. So the question was, is that all it is? But now 2 years, or actually over 2 years later, and it's just conjecture. I think there's something going on there, because I'm asking specific questions, and we're kind of beyond the we don't like them. I mean, we don't like them, but they're going to extraordinary measures, spending a lot of money on their attorneys, as what attorneys are involved, and not only that, but now we see with the upcoming annual meeting, the board has said what we're going to try to do now, since this has been so contentious and confusing to them. That we're going to get rid of this unit owner audit provision, and we're going to put that up for vote at the annual meeting in 3 or 4 weeks. So, and this concludes perhaps a half a dozen different rule changes where it started. What is come to Campton? The door is open. Nope, not so fast. We'll give you copies. Back and forth on the copies. Oh, okay. Now you can do an audit, Bob. You need a CPA, and this is how it's going to work. Okay, let's do that. We show up, Representative Almy mentioned, got 30 minutes, maybe 25, in the building. Not enough time. My accountant is frantically just trying to copy stuff. And now we're to the point where we're going to shut this down. We're going to get the vote and we're going to shut it down. So I don't know. Is there embezzlement going on here? I don't know. I'm just trying to do an audit. I'm just trying to let the facts, I'm just trying to follow the facts, but I couldn't get the first one done, the financial statement audit, and now we're basically doing more of a fraud examination, and I can't even get started.
Thank you for that. And just for the record, my neighbors don't like me either, so I wouldn't worry about that.
Oh, I'm sorry. I wouldn't worry about what?
My neighbors don't like me either, so don't worry about it.
If I was worried about that.
Okay.
Well, most
Representative
people do
McVeigh.
worry about that, that's why there's just one of me here and not others.
Representative McVeigh.
Thank you, Mr. Chairman. Maybe I should address this to Representative Almy, but I don't see any teeth in here. I mean, I don't know much about these things, but I see nothing in here that would prevent your folks from just saying no again. Is there a way to put some teeth into this?
You have to look at the whole statute. You're only looking at a little piece of the statute. You have to look at the whole
502?
356. So,
Thank you.
Okay.
Well, I would just say, with regards to electronic bank statements, that language is not in there. And adding a non-board member audit committee provision is not there either.
great. Thank you very much.
Thank you.
Okay, now Will, who is in opposition to the bill, or sort of. You're like Gary. You're like yes, and you like parts of it, and you don't like some of it.
Thank you, Mr. Chairman. Will Infantine, Hillsborough, 16. I am in favor of the bill. I have concerns with some of the wording. I've been on a number of boards, as I said, over the years, and transparency with finances is always paramount, and it should be. Okay, there's no reason in today's technology. I'm on 2 boards right now, a homeowners association and a condo association. Every month, I got a list. I got the bank statements. I got a list of every bill is paid. We have to get copies of the checks. It's pretty simple with today's technology to provide that as a board member every month to review the information and then to give it to anyone who wants to see it via email, whatever. So I have no problem with 2A and 2C. Most bylaws I've seen allow for individuals to be able to go at a certain place at a certain time that's scheduled to go look at the information. You're paying the bill, you should be able to see where the money's going to. The problem I have is in section B. In the CPA world, there's a difference between a compilation, a review, and an audit. It's all verification of a certain amount. It's all a level of verification. Compilation is the simplest. It looks brief verification. An average compilation would be $25,000 to $3,000. A review statement does a little more independent review. They send, they're going to check bank statements. They're going to send out a certain amount of letters to all the receivables and payables to make sure and get the response back that they're accurate. And an audit, full-blown audit, a review could be $5,000 to $7,000. An audit could be $10,000. So while I respect Representative Almy for having, as she said, a purposely vague comments in or wording in lines 9 and 10, some words were mixed around. If you're going to have an independent review, be careful when you use the word review, because what it possibly means. Are you talking about a CPA review, which is going to cost $5,000 or $7,000 a year? That's okay for a 100-unit association, but not for a 10-unit association. That's a significant expense. It's also difficult to get a CPA or anyone to do something every 3 years. So you're going to say, I did it this year. I'm not going to wait 3 years because I don't know what happened in between. So I got to go back and look at everything else in between there to make sure that my third-year audit is going to be consistent with follow-through with what I did in the audit 3 years ago. This independent review, what does that mean? A guy who, your neighbor who does an H&R Block thing for everybody and does their taxes at the end of the year? Or is it a CPA? Is it someone within the association? Is it someone not? The previous the gentleman testified didn't think that it was okay to have someone within the association do it. They didn't think they were a step away from it. So I think the wording just needs it to be clarified there, because if you're asking everyone to do an independent review or have a CPA do it, it's a significant expense. I'd rather have that say may obtain, because some associations do. I've gone to association meetings where we had a police officer there in case things get out of hand. Other associations, everybody looks at the numbers, everyone's happy. It all varies. Okay, so everyone should have the right to see information, make a schedule, make an appointment, go see it, get all the information. Everything should be transparent. How you do it in B is very important because it could be very costly. So I would hope that could be tightened up a bit, Mr. Chairman. Thank you.
Okay, thank you. Yes. It was in below for the question.
Thank you, Mr. Chair. Thank you for taking my question. On line 11, it states any owner at their own expense may demand a more detailed audit. So it's up to the owner, it seems, to pay for the audit.
He's looking at the first sentence.
Looking at 9 and 10.
See, the first sentence says they have to do an independent review.
If they do a bare basics compilation and that's not acceptable to the person that wants more and they want to pay a CPA to do an
Right.
audit and pay the extra $5,000 or $7,000 to do so,
Okay.
knock yourself out.
Okay.
But 9 and 10, I think the lines 9 and 10
this
need
is
to be a little
maybe
more specific.
To the board. Okay, thank you.
To the condo association. Yeah. Okay,
Thank you, Mr.
thank you
Chairman.
very much. Okay, Gary, who wrote support and oppose. But only 1 to 2 minutes, so you're going to be brief, right?
I am, yes, thank you. By the way, just to make sure records are straight, did I invert the number at all on that card? I don't know if I wrote the right number.
239, you got it right.
Okay, thank you. Okay, so for the record, once again, my name is Gary Daddario. I'm an attorney and a partner with Marcus Enrico Emmer Brooks. We focus our practice on community law and condominium law. So, this is what we do. This is what I do on a professional basis, day in and day out. I am certainly not here to say that I have any issue with transparency or with associations' financials being accurate or with there being mechanisms for them to be accurate. So really, I only have 2 thoughts for you to consider. One is in, I believe it's 2C, where there is reference to individual accounts and that the individual account sort of becomes part of the publicly available information if there is a lien against that unit owner. I would caution that that may not be enough from the standpoint of the federal Fair Debt Collection Practices Act. That act prohibits the release of information about an account to third parties. And as of right now, it is uncertain whether or not they even consider the mortgage holder who provided that $200,000 for the unit to be purchased to be a third party. So I have to believe that they would consider all of the other unit owners and whoever they might share that information with to be third parties. And so while the lien itself that exists at the registry is a public record and would show that that unit owner owes a particular dollar amount, at least at a certain time, their account information would be a different story. Their account information might show more of a balance. It might show partial payments or payments or, a checkered payment history. It could have any number of pieces of information in an individual unit owner account that, if shared, would expose the association to that liability for sharing that information with a third party. So I think there might need to be some tweaking there so that associations are not required by New Hampshire law to give up information that might otherwise violate the applicable federal statute. Just something to consider. I'm sure it can be worked around, but again, something to consider. My second thought relates back to the bill that we just got finished talking about. And my thought is this. I would ask you to give serious consideration to whether or not you legislatively impose on associations additional administrative expenses in their operations if they are going to continue to be unable to end delinquency cases even when unit owners haven't paid them for 1 to 2 years. Because whether we're talking about hundreds of dollars for a simple review or thousands of dollars for a more complex review, if an association is suffering with long-term delinquents and if years are ticking by with balances growing and condo fees not coming in, and if they don't have an ability to do something like a foreclosure to end those cases, to get paying owners in those units, then I just don't think it makes sense. Some of them, as I mentioned in my prior testimony, are having trouble making ends meet now They're operating at a deficit. So I think we should be careful in telling associations that by law, you're going to have to incur additional expenses. And that's all I have on this. Generally speaking, again, no problem with financial transparency, just I think a couple of things that need to be considered.
Great. So when we do our subcommittee, you might want to come in with text that you think is probably more appropriate.
Sure.
That'd
Happy
be
to
great.
help.
All right. Seeing no questions, thank you very much.
Thank you.
Okay, having no more cards, we'll close the public hearing on 239 and the blue sheet. Did we get the blue sheet for 239? Okay, well, I'm not going to worry about it at this moment. So we'll just go ahead because we're really late now. And so I have only one card. Representative Magniti, are you going to testify? I don't have the prime sponsor's card. Is Representative Stavis here? So you're on. Good morning, and I apologize for our lateness.
Thank you, Mr. Chair, and thank you, members of the committee. I want to start by offering you two apologies. And one is that on the copy of the bill that you have before you, at least I believe that's true, the co-sponsors are not listed. And they are Latha Manjapudi and Eric Gallagher. And my second apology is that I intend to work up a slight amendment to the bill, which I will talk about in just a few minutes. So thank you very much. This is a bill that seeks to provide some protections for homeowners associations, which come in all shapes, sizes, and colors in this state, from the purchase by a single corporate entity or one individual of all or the majority of the units in the development. These homeowners associations do not enjoy the protection of any New Hampshire statutes, as do condominium associations. Homeowners associations are for the most part organized under the Voluntary Associations chapter of New Hampshire law, section 292. And so this seeks to prevent undue expenditures that would fall to a municipality should a majority owner purchase the majority of homes or all of the homes in a homeowners association, and therefore the municipality that approved the homeowners association development in the first place would be stuck with the costs of infrastructure of maintaining that community, which would normally devolve upon the homeowners. So that's what this bill attempts to do. And it is an amendment to the Voluntary Associations chapter, under which many homeowners associations in this state and other states are formed. And the amendment that I mentioned a little earlier would be under, in line 7, under Roman numeral 2, and it would say no homeowners association constituted under this chapter and approved by a planning board shall be dissolved, et cetera, prior to a hearing under RSA 676:2 before that planning board. So in other words, I'm taking out the possibility that a homeowners association that does not have any planning board review and approval would enjoy the same protection that this would under this proposed bill. And that is the sum total of it. I thank you for listening, and I'd be happy to answer any questions.
So, go for me, because I was maybe paying enough attention. What exactly is the problem? Do we have a historic event that occurred? Can you walk me through something that occurred that was so problematic that we need to pass this legislation?
We have a worry, not a historic event, but a worry about a future event. We have investors coming into our homeowners association on a regular basis asking residents, what's it going to take to get you to move? I have a check right here. How big do you need the check to be? And these are usually corporations, hospitality corporations that would like to purchase all or a majority of the homes in the HOA and turn them into short-term rentals. So not a historic event, but worry about a future event.
Okay. All right, thank you. Seeing none, thank you very much.
Thank you.
Okay, Margaret Burns from New Hampshire Municipal Association, I assume, is opposed to the bill.
Good morning, members of the committee. My name is Margaret Burns. I'm the executive director of the New Hampshire Municipal Association. We are opposed to the bill, but only with respect to paragraph 2 or section 2, which deals with the required hearing before a planning board in the event of a dissolution of a homeowners association. I have spoken to Representative Stavis before the hearing about the amendment that she spoke to the committee about just a moment ago, and I think it would fix our concerns with the bill as written. Our concern right now is that a hearing would be required before a planning board, even in a situation where the HOA wasn't a condition of approval on the subdivision or the site plan for that particular development. And we don't want to create a situation where planning boards are put into a private homeowner type situation where they really don't have regulatory authority. But in some instances, when site plans or subdivisions are approved, the planning board will actually make it a condition of approval that a homeowners association be formed for the specific reason of taking care of maintenance or preserving conservation land or other easements, because it's a privately owned development as opposed to one that is creating public roads or other public infrastructure that the town would normally have the responsibility for. So we completely understand what it's seeking to address, but with the amendment that Representative Stavis described, it would probably take care of the concern we have about mandating a planning board hearing in all circumstances of an HOA dissolution. So that is all I have for testimony. I won't prolong my testimony, but I am happy to take any questions that the committee has.
Okay. Normally I would think the municipal association wouldn't take an opinion on a bill that's, in the words of Representative Kirk, it used to be prophylactic. We're trying to solve a problem before it occurs. So obviously increasing responsibilities now the town to get involved in it. So are you not concerned that this is preventative medicine rather than addressing a problem that really occurred?
Again, we support the intent of the bill and the issue it's trying to fix. The reason that we have opposition is that it mandates a planning board hearing in all circumstances, even where the planning board has not exercised its local authority to require that HOA to be formed in the first place. So you are 100% correct. Normally, we would not take a position on a bill that's seeking to actually get ahead of a potential issue down the road. The concern is that planning boards will be required to hold a hearing even where they have no regulatory authority with respect to the HOA dissolution, which could create a lot of confusion both for planning boards as well as for homeowners in the HOA. So the amendment described, I think, would ameliorate that issue.
Got it. Okay. Any other questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, Representative Almy wants to weigh in.
Just briefly, you asked Representative Susan Elmy on Grafton 17, you asked about a historical incident.
Yeah.
We have already had one, and we came before this committee to provide a solution which I thought was completely inadequate, and I like this one better. But it was when somewhere in the Eastern Lakes region, I believe, there was a group of people that were friends in Massachusetts that put together a homeowners association on a lake, and they built their nice homes next to it. and they were planning on selling other lots in order to get them to pay back some of their expenses. And they were not getting anybody buying them because the market was not good at that point. And they dissolved the homeowners association by themselves. And 10 years later, they decided to start trying to sell the lots again. The market was better. People moved in. There was a voluntary agreement made that everybody would pay into the common pot to pay for snow plowing and things like that. 10 years after that, the original board, which was still running the place, decided that we can get some of our money back from those earlier years. And they made it, they refiled as the homeowners association. And they then sent a bill to the people, the new people, telling them that they owed what they had already paid. They owed that again as back 10 years of homeowner association dues when they hadn't been a homeowners association. And that went through the court system. I don't think it went to the Supreme Court eventually, but the Superior Court. And I can't quite remember what the resolution was, but it wasn't totally satisfactory for those 10 other lots. And what we did and what you passed was to say that the Secretary of State's office, which they had filed with as a voluntary corporation, was, I don't think it was quite those words, but they had filed with, had to hold a hearing before such a institution could be dissolved or reconstituted as the same one. And that is in law now, but A, most places wouldn't know about it, and B, the association members that were being fined essentially for previous years were wouldn't know about it. So
Yeah, I only thought you could do a 3-year look back.
yeah, so that is a historical incident, and I'm pretty sure there have been some others with homeowner associations.
Fair enough.
But with that
Great.
kind of
Well,
situation.
thank you for contributing that. Okay. Seeing no more questions? Okay, having no more cards, we will close, I will close the public hearing as soon as I have the blue sheet, assuming there's not much on there. For the members of the committee, I have scheduled for next week, I don't know if it's been sent out yet. It has been, okay. And so what it turns out is that the following week, it turns out the Fish and Game only has one bill. And so that means their committee room time is actually open on a Tuesday. So as I've said to you all before, the idea of having a Friday day for the Commerce was an anathema for me. And so pay attention now to that calendar, that Tuesdays potentially will be a day where we'll have hearings. But not next week because they're sharing it with 3 committees for that committee room. But so anyways, going forward, and more importantly, we have 6 bills that have an early departure date, and which means they're going to a second committee. And so I've got those all scheduled for next week, the hearings, and then we would be doing the subcommittee's work on those bills the following week, February, I think it's February 1st, Wednesday the 1st. We'll need to get the subcommittee work. We have to vote on them by the 16th, so I usually like to schedule a couple of subcommittees so we have plenty of opportunity to work on those bills. And obviously, yes, the marijuana bills are, one of them is a early departure bill, so we need to really delve into it. It's 34 pages long, and I haven't gotten my red pen out yet, but I'm hoping that we will not try to sort through a 34-page bill in 2 weeks. So we'll see how that goes. But at any rate, just want to give you all a heads up on that. Otherwise, we're adjourned, and I'll see you all back in an hour. In an hour. Okay. Did we get the sheet? Yeah. open up the public hearing on 383 and hear from Representative Roquefort. Good afternoon.
Good afternoon. Thank you, Mr. Chairman and members of the committee. My name is David Rochefort. I'm a representative from Littleton. I represent Grafton 1. I'm a second-generation pharmacist, and until last February, I was a pharmacy owner. I currently work part-time as for a pharmacy management company doing part-time work around the country. But the bill I'm about to present, HB 383, this is not an earth-shattering bill. I'm going to save you from widespread PBM reform today. It's not a new concept. In fact, the New Hampshire legislature has recognized this issue that's presented in HB 383 as a relevant issue, and the overall major tenets of 383 are already found in RSA 402N. I see HB 383 as more of a modernization of current law, and it just closes some loopholes to make the current law work a little bit more efficiently and make it more work as intended when it was first passed. I'm going to talk about it here at a high level, but I do have some current pharmacy owners here with me to get into some specifics, to answer some of the specifics and how it functions in real life, if you will, who will come up after me. However, before I get going, I do want to define some terms that will be used today. I think it's important. I understand that these terms are very specific to our industry, and I think it might be helpful to understand as we move along. So the first term I want to define is a pharmacy benefit manager. You'll also hear this term defined as a PBM, three-letter term. PBMs are middlemen companies that insurance companies hire to carry out their drug benefit. The PBMs, in turn, not the insurance companies, contract with the pharmacies to assemble a pharmacy network. PBMs determine which pharmacies will be included in a prescription drug plans network and how much said pharmacies will be paid for their services. And I think it's important to note that three individual PBMs control 80% of the drug benefit transactions in the United States, and all of them own their own pharmacies. The other term that I want to discuss is MAC pricing, MAC. So in an effort to control costs, PBMs frequently utilize a pricing concept called MAC, or maximum allowable cost. The MAC is the maximum amount that a pharmacy benefit manager will reimburse a pharmacy for the cost of a drug. This is a contracted agreement that the pharmacy will take whatever the PBM has decided to pay them for a particular drug. And because drug prices fluctuate frequently, the MAC reimbursement oftentimes doesn't keep up with the drug prices, especially in the volatile drug price markets we've seen lately. So the concept is important to understand, especially as consumers, being that MAC is a contracted agreement between a pharmacy and a PBM. It's not like going into the market basket and seeing a dozen eggs and saying, I'm only going to pay $2 for this dozen of eggs when they're selling for $7. They're contractually obligated to take whatever price that the PBM is telling them to pay. So it's a contracted agreement, and understanding that these prices are fluctuating every day. The other concept that we've heard a lot about in the news that I just want to remind folks here today about is transparency. And as we talk about transparency in drug pricing, there appears to be room for improvement in the manner in which PBMs communicate MAC pricing and the sources of the products to which MAC pricing has been applied. Unclear and opaque methodology is a relic of the past, and we all understand that a hidden market is not a free market. So I mentioned previously that the concept in HB 383 is not the first time the legislature has had MAC pricing in front of it. In fact, we have statutes on the books dealing with this issue. So this bill, HB 383, is not a radical new legislation. In fact, SB 226 of 2019 established that if a PBM had a maximum allowable cost, or a MAC pricing, on a given drug that was below the available acquisition cost for a pharmacy, the PBM had to provide the pharmacy with a source where the drug could be obtained at or below the MAC price. So that means if a pharmacy submits a claim for a particular drug, amoxicillin, and the reimbursed claim comes at below the drug price that's actually cost, and that MAC price is below the actual acquisition cost, that PBM has to supply a source to where that pharmacy can buy that drug at that lower price. That's in law already. This bill closes a loophole. HB 383 in front of you closes a loophole in the law, and it states that the PBM must provide the pharmacy where what wholesaler doing business in New Hampshire, where that drug is available at or below that MAC price. So it kind of finishes the sentence of what we have in statute already. This bill also requires that the PBM notify all pharmacies in the network when it finds that a MAC price is below acquisition costs and allows them to rebill at the more appropriate reimbursement rate. Current practice is that a PBM provides a portal that a pharmacy must log into. But given the technological advances employed in modern pharmacy, this information can be transmitted and disseminated instantly. PBMs can actually calculate prescription deductibles in real time. They can do, because they can do this, and because that technology is available, they certainly can communicate out to pharmacies when and where these prices are available. Again, this is not radical reform legislation. I'm not here to provide you or present to you some type of groundbreaking legislation that's going to rock this world. It just cleans up some areas that we found in previous legislation that we feel need improving. So I'm happy to answer some general questions about this, but like I said, I've got pharmacists here that have come out today that have taken time off of their work to answer very specific questions. They're here to answer your questions on how this would work functionally in their pharmacies today. So if you have some questions for me, I'd be happy to answer them. Otherwise, I'd be happy to turn this over to them.
Yeah, I don't have any other cards. Do they?
I left some up there for you.
I don't know. Well, these are. Yeah, but these are opposition.
I left them with mine. I left a card and I left theirs. I told them to leave theirs up there too.
All right. I'm all set. Okay, so Glenn Perrault? Yes. Come on up. Oh, someone had a question? I'm sorry. I didn't see the hand.
Yes, thank you.
Yes, Representative Gibbs.
Very briefly, will the proposed change have any effect one way or the other on consumer costs, and if so, what?
So I think anytime that you improve transparency in pricing, anytime that there's an effort to make the process more visible, whether it be to the pharmacies that are participating in it, I think that there's always an opportunity to improve costs. The concern that I have when continuing on the process that there is now, when pharmacies are forced to sell drugs at below cost, or because again, this is a contracted agreement, they're just not going to carry the drugs. And they're not going to participate in these programs. And if you need a drug and this is continually being what we call MAC'd at below cost, the pharmacies are not going to carry the drug. So, it could affect cost, improving cost prices, but it certainly will affect access to care if this continues on. It's my opinion.
Well, it's funny you say that, because I was sitting there saying to myself, if they're going to tell you, the PBM's going to tell you where you can get it at this low price, that means you didn't have it in stock in the first place.
Absolutely. Well, with these MAC prices are generally applied to multi-source generics. So if you have amoxicillin, for instance, which we use for sore throats and antibiotic, there might be 12 different companies that make amoxicillin. So my wholesaler might sell 6 of them, 8 of them, 10 of them. But if they're basing their MAC pricing on that 11th or 12th product brand that my wholesaler doesn't have or is available that we don't know about, we want to know about that, and so we can bring that product in and sell it at that lower price, and therefore comply with the MAC pricing.
Right, but you don't want to sell it below cost. I get that. You have your wholesaler who you used to using, and then it turns out that there's somebody out there that has it at a lower price, and now we have it a chicken and the egg. How you're saying that they need to let you know, the PBM needs to let you know ahead of time when they don't even know who you're getting it from in the first place, right?
Well, and I can let these guys can speak to that a little bit clearer because they're dealing with the wholesalers on a daily basis and their contract with them, and they can
Right.
tell you how that functionality will
Right.
work. And I'm going to let them answer that question.
Right. So just so you know where my thought was, as soon as you had said, "Oh, there could be a lower price," my first reaction is, "But you're going to have to tell the customer, I'm not going to sell it to you. I'm not going to give it to you today because I don't have it at the price point in which the insurance company's PPM is going to reimburse me at."
But if I have it in stock, and I'll let these guys comment on that, we have to sell it at that price. We have the product in stock, and it's on our shelves, and we transmit a claim for that product.
Right.
We have to sell it even if it's below our cost. So we have to sell it, but contractually obligated to sell it at a loss.
Okay. Well, that's interesting. All right. Thank you. All right. Now, Glenn.
Hi, my name is Glenn Peralt. I'm a pharmacist and also a pharmacy owner in New London, New Hampshire. And I'm here obviously in support of this bill. There are several instances that come up weekly that Dave was trying to describe where I have current stock on my pharmacy shelf and being reimbursed below what I pay for that drug on my shelf. I either submit a request for adjustment or I have a party submit an adjustment on my behalf. And many times that request is unsuccessful. And if it is successful, I get a very brief note back from the PBM saying that the product is available cheaper in the marketplace. That's the end of it. I have no idea where to find it. I have no idea if it's even a U.S. supplier. Like Mr. Rochefort was saying, Representative Rochefort was saying, if that product is on my shelf, I am contractually obligated to sell that, to fill that prescription and sell that product, even if it's at a loss. The contracting process that we undergo with the PBMs is not a negotiated process. It is a take it or leave it. You may have access to our patients if you accept this rate. I can speak personally right now for calendar year 2023. Our pharmacy is unable to service around 800 patients because of contracts that were offered to my pharmacy 7% below my acquisition cost. I have no recourse. I have to find a home for my 800 patients. What this bill will do is it will put some onus back on the PBM to identify a supplier in the state of New Hampshire that I can purchase medications for to fulfill my contractual obligation. And I'm happy to entertain any questions.
Well, that's pretty straightforward. So,
And I have an open invitation to any representative who wants to come up in the pharmacy and just see what we do every day and see what I'm trying to explain in action.
So the PBMs right now have no particular obligation to let you know who they want you to have as a wholesaler.
That's correct. And there's even some MAC responses that we get back where the product in question is not the product that I am requesting a MAC adjustment on. For example, there may be a 2-ounce tube of cream that says, no, our MAC is fine, order this particular, every drug has what's called an NDC number, a National Drug Code. They provide me an NDC number, and what I see time and time again is an NDC number for a smaller pack size. Well, of course, that pack size is going to be below your MAC for the 60-gram pack size. This is just some of the real-world situations that we're dealing with in the pharmacy, and what we're hoping that this bill will address and clean up.
Good. Now we have questions. Representative Spear.
I know that a pharmacy has a limited size and shelf area and expiration dates on drugs and things like that. What would you say the percentage of drugs are that of what you have in your area, of what people want, are actually available that you would not necessarily have to go out and just say, all right, I'll get it back to you in 2 days?
So I would say that we probably fill between 95 and 99% of all the prescriptions that walk through the door. Very, very rarely do we have to make a special order for an item. Our pharmacy is a very, very busy pharmacy. We fill upwards of 10,000 prescriptions a month.
Wow.
And so we typically have a fairly substantial inventory.
So you could be hit with this MAC limitation, if you will, across a lot of drugs.
So my MAC requests in my pharmacy, generally there is about a dozen to a dozen and a half MAC adjustment requests per week. And I would say out of that dozen and a half, I would say less than one are adjusted. I would say out of 100 MAC requests, we probably have about 2 that are actually adjusted. And the difficult part about the adjustment and allowing us to go back and rebuild the claim is this time of year we have several people who are meeting deductibles. And so we transmit the prescription off and the patient's not paying a copay, they're paying the full adjusted price of that prescription. And so now I go back 2-3 weeks later, rerun the claim, and it tells me that I shouldn't have charged the patient, $150. I should have charged the patient $170. Well, I'm not going to call the patient up and say, oh, by the way, you underpaid by $20. You got to come back. It's a very difficult situation that we're put in.
Representative Vincent.
Thank you, Mr. Chairman. And thanks a lot for taking my question. This PBM's company, is it negotiated? You may have said, but is it negotiated by the insurance company? Do they hire these people?
So it's yes, a PBM. So an insurance company, say Anthem Blue Cross,
Right.
does not handle prescription claims at all. They say they will hire, and I believe in Anthem's case, they hire a company called Express Scripts, and they said, you handle our insurance. You do all prescriptions. Run it the way you want to run it. The PBM will come back and say, okay, do you want to allow 90-day prescriptions at retail? Do you want to have a mandatory mail order? They set up all the rules, and the insurance company says yes and no and yes and no. And that is offered. Now, after all those questions are answered, the PBM will take that contract and will present that to the pharmacy. Whether it's an independent like me or whether it's a chain store, they will say, this is how that plan works. This is your reimbursement. You can either choose to service these people or not.
One
And
quick
s-
follow-up.
For the question.
So how long has this issue or problem been exists? How long has this been going on?
So I have been a pharmacist in the state of New Hampshire since April 14th of 1984, and it's been a challenge since then. Not to this degree. Not until recently, over the last 4 or 5 years, have we been seeing the number of underwater claims at the rate it is now, and it's to the severity it is now. My last contracts that I had to refuse were offered at 7% below what I could buy the drugs for. And speaking to some of my colleagues and asking them what some of their buying contracts are, it's across the state. It's not just me. And I have a big pharmacy. I mean, I have a very busy pharmacy. We have great buying power.
Thank you, Mr. Chairman.
Representative Terry.
Thank you. So my question, hello, hi.
Oh, hi, thanks.
Hi. Yes, you can't tell the players without a scorecard. Right here. So I want to make sure that my question is going to be predicated upon my understanding, an accurate understanding. So if it's not, please, you charge $25 for, you pay $25 for a particular drug, all right? And the pharmacy benefit manager comes back and says, we're only going to give you 15. All right, got it?
Correct.
Right. You ask them, who's the wholesaler?
Correct.
And
Where-
they won't tell you. They don't tell you. Have you asked them why they will not tell you?
Have we followed up?
Have you ever asked them, why will you not tell me how you came up with $15? Who's the wholesaler? And if that's the case, that they will not tell you, then do you have any confidence that they're telling you the truth if they won't tell you?
That's correct. We don't.
That these are just maybe made up prices?
Well, we that's right. We don't know. And to this point, we don't know how to proceed and challenge that. We know that the Insurance Commission is responsible for enforcing the statutes, but we don't know the avenue in which to pursue and who to pursue at the Insurance Commission. We constantly run into roadblocks with the Insurance Commission trying to enforce some of these pricing models.
Okay, thank you. So I guess we want to hear from the PCMs, PCMAs. Curtis, you guys, yeah, we try to go back and forth. So you're going to hear their story, and then you'll be able to come to respond to what they say. I assume the two of you are going to be tag teaming?
This is who passed this out.
Okay, yes, yeah.
Thank you. Good afternoon, Mr. Chair, members of the committee. My name is Curtis Barry. I'm here on behalf of the Pharmaceutical Care Management Association, otherwise known as PCMA, which is the National Trade Association for the PBM industry. We have several members that are active here in New Hampshire. With me is Sam Hollemeyer from PCMA. And before I turn it over to Sam for the primary testimony, I wanted to point out I've left a packet for each one of you and wanted to walk through that real briefly. The first page would look like this, sort of a chart that describes the supply chain and the reimbursement chain for pharmaceuticals. It is fairly complicated, and it's not like other medical suppliers. So you start with the drug makers, obviously. The physical drugs that the pharmacists are talking about are then transferred to a wholesaler, which then sells to the pharmacy. On the other side, on the right-hand column, you have a PBM, which can be contracted with an insurance carrier. Some carriers do the PBM services in-house. PBM can also contract with a self-insured large employer. And the patient is a member through their health benefit with their employer. So the pharmacy benefit manager does exactly that. It manages the pharmacy benefit for either the employer or the insurance company. Importantly on this chart, I want to point out that the wholesalers have no direct connections to the PBMs. They buy their drugs from the manufacturer and sell to the pharmacy. We cannot, any PBM cannot dictate from whom a pharmacy purchases drugs and cannot get involved in those negotiations. The negotiations for the purchase, those contracts, if you look at the second page, typically are handled by what's known as a PSAO. Sam will get into that a little bit more, but a PSAO is a Pharmacy Services Administration organization that serves in part to negotiate contracts between PBMs and pharmacies. Also to negotiate, I understand, between the wholesaler and the pharmacy itself. So if somebody knows the information that they're looking for, the wholesalers know what their prices are. Maybe we should be talking to them about their pricing. They're the ones that are, we heard testimony, that are causing the fluctuation in the price that the pharmacy pays. Or maybe the PSAO, who is involved in negotiating those contracts. The next page, I've provided for you the full text of the current statute that was referred to previously. And based upon a recent comment, I want to point out right at the very beginning, Roman 1 small a, all contracts between a carrier or a pharmacy benefit manager and a contracted pharmacy shall include the sources used by the pharmacy benefit manager to calculate the drug product reimbursement paid for covered drugs under the pharmacy health plan. So we are required to show them how the MAC price was achieved, in essence. And then there are other provisions in here related to what happens if the claim is denied, which also requires some information. There's a copy of Sam's testimony here, and then a one-pager on MAC pricing in general. And one more point I'd like to make for the committee's information. New Hampshire is what's known as an any willing provider state relative to pharmacy. That happened an awful long time ago.
Donalita Lozo.
We won't tell the story, but in essence, New Hampshire statute for 30 or so years states that a pharmacy must be let into the network if the pharmacy is willing to adhere to the terms and conditions that's offered by the insurance carrier or the PBM. In other words, the PBM or carrier cannot cherry pick or just decide, no, we don't want you in the network just because. Every pharmacy must be let into the network if they're willing to adhere to the terms and conditions. So with that, I'd like Sam, turn it over to Sam for the testimony.
Thank you, Curtis. Good afternoon, Chairman Hunt, Vice Chairman, and members of the committee. My name is Sam Hollemeyer. I am Director of State Affairs for Pharmaceutical Care Management Association, PCMA, which is the PBM National Trade Association. And I'm here to oppose House Bill 383 today. Before I get into the bill, I did hand out, as Curtis mentioned, some written testimony. I do want to highlight exactly what MAC is. Again, it's maximum allowable cost. A MAC list specifies how much a PBM will reimburse any given pharmacy on a generic drug. A generic can be made by several different manufacturers and sold to pharmacies at different price points. Because of this, PBMs set and regularly update the MAC list by surveying market data from nationally recognized pricing reference services, wholesalers, as well as drug manufacturers. The purpose of a MAC list is to encourage a pharmacy to purchase drugs, to purchase generic drugs at the lowest price that they possibly can, driving competition amongst wholesalers and keeping costs down for patients. PBMs have no insight to the relationships between pharmacies and wholesalers, so I'm going to end on that. Now to get into the specifics of the bill. So Section 1, Sub B would require PBMs to notify the source a pharmacy can purchase a drug at or below the MAC price. There was discussions earlier on that the PBM would have to require to notify a pharmacy of where that MAC price came from. But with this bill, would not require that a wholesaler sell it to that pharmacy at that price. I think that's what a big point is missing here, that these pharmacies want to know where they can get that price, but there's no guarantee that the wholesaler can sell it to them at that price. Again, those are negotiated rates between a pharmacy, a PSAO, and a wholesaler, not the PBM. The PBM has no insight to that information. Next is Section 2, Sub B. There's the phrase actual cost is in here. There's no definition in New Hampshire statute, and we're pretty unsure of what that might mean. So we had a question on what actual cost was. Again, that's Section 2, Sub B. Again, Section 2, Sub B would require PBMs to notify all pharmacies of a MAC list change. PBMs have no way of knowing if a pharmacy purchased a drug below or above a MAC price unless they let us know. So we're unsure of how notifying them would work for us. And then finally, Section 3, Sub D, would require that PBMs supply our MAC lists to the insurance department. These MAC lists are hundreds of pages long, and they're updated frequently. So it's a huge burden for the department, in our opinion. And we already supply them to the pharmacies. So we would suggest or request that we strike that from the bill. Thanks for the opportunity to testify today, and I'm happy to answer any questions.
Boy, let me get this straight. You're going to contend there's a MAC price at a certain dollar amount from a certain wholesaler, irregardless of whether that wholesaler even sells into the state of New Hampshire?
The data that we receive, I believe, is from the state of New Hampshire and just markets in general in the area. Yes.
So would there be volume discounts?
There certainly are, but we are not aware of those volume discounts provided to pharmacies.
You are aware of a MAC price. You
Correct.
have a price.
They're reported to us, yes.
And that MAC price doesn't take into consideration that this was only supplied to a certain large employer?
I'm not a-
like ERISA, that it wasn't available even in the small group market, that price was a negotiated price between a big corporation and that wholesaler, that they've got that negotiated price. You're using that as the basis, but that price might not available for anybody else but that corporation.
I don't know that answer off the top of my head. I'd have to go back and look, Chairman.
Do you follow where I'm going on this?
I do.
Curtis does. Holy moly. Okay. Representative Vincent.
Thank you, Mr. Chairman. Thank you for taking my question. So let me get this straight, because I am a little in the fog about this. On January 1st, I'm a pharmacist, and I buy something for $10. And on January 15th, it comes in and it's changed by the PBM's dealer. It's $5. Is there any time between the 1st and the 15th where there's a notification process to let the pharmacist know if it's going to go down or not?
Yes, the pharmacies have access to a portal where they can see a MAC price reimbursement in real time.
So it's up to them to go find it.
Correct. These MAC lists are also provided to pharmacies regularly, but yes, there is a portal available for pharmacies to view that price.
Thank you, Mr. Chairman. Thank you.
Okay, Representative Sullivan.
Thank you. Yeah, I'm just curious, following up on Representative Vincent's question, how often are these portals updating? Like, is this something that's updating every day, every week, every month, every year?
Currently in statute, PBMs are required to update it every 14 days.
So I don't know the business really at all, but could a pharmacy buy a certain stock of product and it would maybe last 2 months, or are they just buying 1 week's worth of time, and so that's actually a relevant amount of time?
I can't answer that, unfortunately, Representative.
Yes, Representative Gibbs.
Thank you. Can you tell us if any other states have requirements such as those provided in this bill? And if they do, if those requirements cause any problems?
Thank you, Representative, for the question. Could you be more specific? Is it the whole bill in general, or is there a specific portion of the bill?
I'm sorry, I can't be more specific. This area is very unfamiliar to me, and it's a very complex situation. And you're testifying against the bill, but nobody has mentioned how common these types of requirements are. And so that's what I was asking, and I was hoping you could.
So, this is interesting. How many states have that any willing provider statute? Because I remember when we had this floor debate, and I said to Donna Lee, there could be, the pharmacist could be having to, just because they want to service the customer, they could have to pay more because they don't have the volume that a different pharmacist might have. And she said the pharmacists just want to be able to take care of their customers. That was what the floor debate was.
What specifically, I'll get you that information. I don't know that.
But I think that's what, it was the debate around the any willing provider issue.
Sorry, could I go back to my question?
Yeah,
Do
so
any
what your
other
question
states-
is
do
that
any
is
other states
other
have these
states have this
requirements?
problem? And the
I-
answer would be is, how many other states have the any willing provider statute?
No, I'm afraid not. It's the transparency requirements that I was asking about.
Representative,
Transparency
thank you.
requirements proposed, I understand that we have the any willing provider statute, but this bill then goes to transparency requirements, as I understand it. And what I'm asking is, are there other states that have these transparency requirements? And if there are, do those requirements cause any problems?
I don't have that information readily available, Representative, but I'd be happy to look into it and follow up with that information.
Thank you.
Right.
Thank you.
So just so everybody understands what this any willing provider statute was about, it was about that theoretically, if you want your volume, you want to get the best price from your pharmacy, for your pharmaceuticals, generally the insurance company is going to steer you to the mail order company. I would say that we won't see a mail order company in here with this complaint, because they know exactly what they're going to get reimbursed, because that's a negotiated price between the PBM and that mail order company. What we're dealing with here is we're dealing with independent pharmacists who are the customers going to them because they don't want to get it in the mail. They want to deal with a local person. And the problem then is that the PBMs do not have individual contracted pricing. They just have this agreement that they will reimburse because we legislated that. Okay. Yes, Representative Walsh.
Thank you, Mr. Chairman. If I understand this correctly, with the PBMs, you say you update through the portal every 14 days or so. So there's potentially thousands of possible price changes. Is that correct?
I don't know off the top of my head how often or how frequently individual NDCs are updated. But again, it's
Take an
all on
educated-
generic drugs.
I would think you would have the, the experience to answer that, I would think, I would hope, right?
Again, if I may, I want to come back to the relationship that exists in this sort of the reimbursement arena. The PBM has no control, zero, over how much the wholesalers ask for their drugs, how often they increase those prices, et cetera. And one of the concepts behind MAC pricing is not necessarily to reimburse for actual costs, because if PBM was required to do that, there would be no incentive for the wholesaler to keep their costs down. They could raise prices to whatever price they wanted, and the PBM is then required to pay those prices. And at the end of the day, it's the premium payers then who would face the increased costs.
Further question, may inquire.
Yes, thank you. I have a follow-up. So, just for example, on Amazon knows all when I buy things, and it says, hey, this has been something you've bought, and here's a price change. So, in this industry, is there any type of data that can provide the pharmacists, the pharmacy owners, that, okay, this is the data on this particular drug, that it's been going down, 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 so be aware. Is there any type of, notification process or data involved as to trending data that can provide them with a heads up in the future?
So like I mentioned previously, there is a portal that pharmacies can take a look at to see what the current MAC reimbursement would be. As far as a trend going down, like your question is, in that negotiated contracted rate, my response would be that's between the PSAO, which was mentioned previously, and the PBM, as well as the pharmacy as well. So they would have to go back and renegotiate that contracted rate if they wanted to update that price. I hope I'm answering your question correctly. So
you're not supposed to admit that.
As far as again, the MAC price reflects what the current market trend is. So if the trend is going down or up, the MAC price will reflect that.
Okay, great. Thank you.
Thank you.
Steve, you got the last word.
Am I on?
Yep.
My name is Steve Cavadias. I am also a pharmacist, and I am also a pharmacy owner in Pennacook. I find all these questions very intriguing, and I do have my own response to all of them, but I can't remember them all. But I would like to respond to your question at the very beginning, if this was going to increase the cost. So if you look at the statute already says that they're supposed to reimburse us at or above cost. We're not asking for anything different. We're just asking for you to tell us where we can get that. So there's basically 3 primary wholesalers, just like there are 3 primary PBMs, that are all involved with supplying the PBM owned pharmacies that the pharmacies use for secondaries. They also have their own pharmacies mail order. So the concept of PBMs not knowing the price of a drug, whoever asked that, is beyond my comprehension. I don't know how they know that, or don't know that. In addition to that, with the way they come up with the MAC, and they're checking all these resources, well, then why are they below cost? And it doesn't really matter. The statute says it's above cost, and we're just asking for, well, where is that? When they say that it's cumbersome, that they cannot provide us this detail, daily on hundreds of claims, I get this person can no longer get refills, it has to go to mail order. This person can no longer get this product, it has to be that product. I get all sorts of messages. Not one says, oh, let's help you find a place that can keep you in business, because although I enjoy taking care of people, I also have to pay my staff. So, any other questions? I tried to address a lot of the ones that I heard. Excuse me for being emotional.
No, you're fine. Representative Vincent.
Thank you, Mr. Chairman. And I don't want to be redundant. I just want to be clear. So you say, it says they change these prices every 14 days as possible. But what happens if you have a big demand for 4 months on ABC medication, and then you stock up on the 1st of a month, and then, hold on, and then if you got 20 cases of a medication, but you have 10 left, and then they change the price, you're stuck with that pricing now. You lose, correct?
Correct.
Thank you.
Well, and I can take this even further. There is a PBM that makes it an auditable offense if I buy a product in bulk outside of the 30-day window of the claim. So now I'm restricted on negotiating for a better price. Ooh.
One more quick follow-up, Mr. Chairman, very fast. So we've looked at it going down. Has it ever gone the other way and gone up?
I can't. Yes, there are success stories of MAC changes. I have noticed recently that I lose less on epinephrine injections, or EpiPens, as everybody is familiar with.
Thank you.
And some of these losses are in the hundreds of dollars. We're not talking trivial pennies. Go ahead, please. Sorry.
What's that? Yep. Representative Calabro.
Knowing how small pharmacies work, being a primary care provider, I wrote a lot of prescriptions for the pharmacy where we worked at our HRSA, but I wrote a lot of prescriptions for my homeless patients for small pharmacies because the prices were very often lower. My question to you is, some of the things that impacted us was that we didn't have enough staff to be able to look up those sites. We had a person that was working that was able to do that for our corporation every day. In the setting of a small pharmacy, can you give me an idea of what the impact would be labor-wise having to look up all that data?
Well, just to give you an answer to how we manage that, and maybe this will answer your question a little bit, is that we use our PSAO, which thank you for telling me what the abbreviation meant, because I didn't know, to do research and to challenge these MAC prices. And so I called my PSAO yesterday and asked them some silly numbers on what this looks like. So from the time of December 16th to January 16th, there were 2,926 appeals, I believe. Generally, I ask them, what is the success rate? And they say generally it's around 5%, but last year it was 7%. Okay. So when I look at the PBM that were on that list, predominantly it's one of the bigger ones. And when I look at the top successful appeals in this past week, it was only one PBM, which of course was a different one. And it's very limited as to the number. So yes, there are people working on this on our behalf. Am I able to fill out a request based on a claim? No. It's hard enough to do a prior authorization that I'm sure everybody in this room is aware of, that you need something. And of course, everybody has to jump through hoops. So there are ways of getting around this, but I cannot do it. You know, we have so many requirements and laws and regulations that we have to follow, and we do it without issue. Whereas we have a law here that's already in effect, and we have to beg to ask them to please follow it. And in the spirit of all working together, well, tell us where we can get this from. Don't make me go through the hundreds of wholesalers to figure out where I can buy this and then restrict me afterwards. And in addition to that, the new game that we have playing is that they're requiring specific manufacturers for some generics that I can't even get, or I can't get on contract, which violates a whole bunch of other contracts that I'm dealing with. I'm sorry, go ahead.
I think that really gets to the problem here is the pricing is based on a negotiated contract. And like I say, it could have been one employer, ERISA, that got that volume discount, and to apply it to every business relationship that you have is impossible.
Correct.
And so, I'm not sure how we can fix this problem, because that's the nature of what PBMs do, is negotiate pricing.
Well,
And so to negotiate, in other words, we all know if you're buying buying a case of something, you're going to get a different price than if you're only buying one of it or small of it. So if you only have one particular client that's in your community who needs this one obscure drug and insists on not getting it through the mail order, but insists on buying it from you, you run this risk of having to give it to them.
Fortunately, I have a law that says that they have to reimburse me above my cost.
They have to reimburse you.
That's what it says here already.
The current law.
Correct. We're just asking to know where.
How to enforce it.
Well, no, that's another issue.
Where
for
no,
another
you have
day.
to buy it. Where you have to know where to buy it from.
Right.
But they don't.
Right.
So
Puerto
the
Rico's
question is,
not on the list.
do they really know that the only way you can get that price is you got to buy a case of it, not just one of it.
But I'm not allowed to buy a case of it with another PBM,
right?
Because that violates that contract.
Right. That's like I'm saying. So it's
it really is a challenge.
You're caught between a rock and a hard place here.
Well, all they do is tell me where I can buy it.
Yeah, but I don't think you can.
Obviously know.
No,
because-
they think they can say you can buy it, but the reality is, even if you were to call that wholesaler who had it, they say, well, that's fine, but you got to buy a case of it to get that price. In other words, they're not factoring in volume discount.
Well, we do. We are involved in buying groups where we negotiate the best prices that we can.
Right.
It's not just me with my small store and Glenn with his larger store.
Because
Our
you guys
pri-
are not a right, you're all independents, right?
Correct,
You're
correct.
Independents.
Our acquisitions prices are very similar, except for a little bit of volume difference in pricing, but not significantly different. And as I grow based on the need occurring, which is where the problem is, I get those discounts, but my losses continue to grow as my business grows because of
These,
some silly little issues of, this is what we say the cost is. We have determined that this is what the cost is. We can look at some sort of compendium and do a discount off of that price to come up with what MAC is. They buy tons of drugs and know what the prices are. Well, tell me, what manufacturer then that I can go to and say, okay, you need to give me the same price because
Right, I got that
we have a
part.
rule here.
Yeah, okay.
That's all. We're just asking for information. And not part of this is the next step is trying to figure out how do we get the state to enforce them to provide us at cost or above. I'm not sure how many people here are business owners or have budgets, but selling things at below cost is not a very good business plan. I mean, I only went to a couple schools.
Well, theoretically, you could say to the customer, I'm sorry, I can't sell it to you because I'm not going to get reimbursed enough.
Well, the point is,
You
is
could
that,
say to the customer, I can't
is
sell
that we're being forced down this road of, well, how do we stay alive? And if you look at the numbers, I mean, it's not like independents are growing every day. Pharmacies are closing. I mean, even the chains are closing.
I got it.
I'm sorry.
Okay, Representative Terry has one more question.
So, the chairman's astute observation notwithstanding, but alongside and coming back to the response given to me by one of the previous folks who was testifying, the other pharmacy owner, the question here is, the problem is they won't tell you where you can get it,
Correct.
right?
To
So
my
do you ever
knowledge.
get the feeling that what they would like is for you to just go away and disappear?
Well, I think
so
that's well
everything can be
documented.
mail order.
That is for sure.
Correct.
Okay, let's just cut to the chase. Thank you, Mr. Chairman.
Very
well-
astute.
very well said.
Okay, Representative Herbert has a question. Okay, I'm sorry.
He's right-handed. Right.
I just want to, I think what we're looking at is a very complicated semi-monopoly system, which really isn't in competition. And my question is there a source that does, in fact, is such a large buyer of drugs that they get the best price the market will
Well,
bear?
the people
Is there a source that buys that much?
Yes. So we buy from the three largest wholesalers in the country. I used to buy from the largest distributor of generic drugs in the world. Okay, so I would think that their pricing would be pretty good.
Yeah.
I was part of their organization through a what's that called, a franchise.
Who was this?
That was McKesson.
McKesson, okay.
And
Which is a drug company. isn't it?
well, they're a wholesaler,
They're a wholesale, okay.
and they also are a PSAO that negotiate the prices for us. And yes, there's a cloud of mystery there. That why is it that are you signing contracts when you know that's not what the prices are higher? There's many layers to this onion. We're just trying to find out where they think we can get this.
My further question.
But we're not buying it from a little wholesaler down the road that can't compete with the big guys. I'm competing with I'm using the same distribution systems. I'm using the same source, the same supply channels, except going direct to the manufacturers, which is probably what the mail orders are doing.
Just one further question.
Further question?
Perchance, does the federal government, are they a customer?
Yes. It's called
Who do-
Medicare.
Pardon me?
Medicare.
Medicare. Okay, Medicare. Well, they also have a lot of people in defense that not on Medicare yet. But
Correct. Well, we have the state, who's a very large employer.
I'm just
Yeah,
trying to
customer.
I'm just trying to identify where you may be able to get the information on not
Yeah.
just a need to know basis, but a portal that shows all the pricing.
That's secret.
Okay, there's the problem.
That's the secret. No, the dirty little secret here is not that anybody likes each other. Is that the whole point of a negotiated price is that it's a negotiated secret. And so, yes, you're basically asking the PBM to tell us their special formula of
Well-
what
well-
was that special price they got with that one particular manufacturer, and they don't want to tell you that.
Can I throw out a silly analogy that I thought about this morning?
Sure.
So the regulation states that they have to pay us cost or better. Now, I have a lot of regulations that I deal with. When I drive, there is nobody standing by the side of the road that says, stop, the speed limit's going to change, look it up, figure out what it is, because down the road, there's going to be somebody that's going to, bag you if you're not right. Let's not put a sign up. We're just going to tell you. And if you're in a hurry and you just blow by the guy, you're not going to go. You're not going to know. Why is it that we all have to follow the rules? And here we have a proprietary situation that has to be secret, and we have to make it all convoluted. And we have to jump through hoops to make sure that they are complying with the rules.
I think you're looking at an antitrust issue. So
Well, let's add a whole nother layer to
Would
this
you
problem.
believe?
would you believe? Yeah, would you believe it's a monopoly?
Are we all set?
Monopsony?
Is everybody all set? I think we got this one. Thank you so much.
Oh, you're welcome.
You did good job.
And I would be more than happy to answer any questions in the
Yeah.
future on
We will be
anything.
having a subcommittee on this,
Okay,
Bill.
awesome.
Okay, having no more cards, I will close the public hearing on 383. And let's move right on to the next one. Okay, next up, House Bill 426, relative to regulations of pharmacists in charge and pharmacies.
It's a federal issue. You just need somebody to come in and apply some antitrust laws.
Okay,
Huh? No.
welcome again, Representative Rochford.
Thank you, Mr. Chairman. Members of the committee, you're going to get all kinds of pharmacy today. But I promise you I won't be back.
Somehow I think I have you scheduled for another day. I think you did.
We'll get this out of your way. This
Okay,
one,
this one, is this the easy one?
This should be easy.
I thought there was an easy one.
This should be easy. This should be easy. I see a lot of pink cards though, so I think that they should be all easy pink cards. So before you right now is HB 426. So this bill actually was put forward as a request from the Board of Pharmacy. So in addition to being a pharmacist, I also am vice president of the Board of Pharmacy. So the Board of Pharmacy has been working since this summer to modernize some of our Pharmacy Practice Act to delineate how a permit is issued. And I know this typically isn't business, but it does relate to how a business in pharmacy is granted a permit. So right now, the way it stands in the state of New Hampshire in RSA 318, when the permit is issued to a pharmacy, it is actually issued to a pharmacist in charge. Or a pharmacist in charge is the one who actually the permit is issued to. Now, the concept of a pharmacist in charge goes way back to when most pharmacies were owned by pharmacists, and the state had to have somebody to go to and hold responsible if there was an issue. And so the issues that would arise that a pharmacist in charge would be responsible for could be as mundane as whether or not there's hot and cold running water, whether or not there was adequate staffing, whether or not the roof leaked, whether or not the door had a lock on it, whether or not the sign had letters that were 3 inches tall. I mean, that's the kind of stuff that's in the Pharmacy Practice Act. I mean, it gets to be that mundane. The problem is you get fast forward to the year 2023, and most pharmacies in the state of New Hampshire, as we learned about just a few minutes ago, are not owned by individuals anymore. They're owned by corporations or by hospitals. So to have an individual pharmacist in charge be responsible for making sure there's hot and cold running water, when many times that person has no authority to call a plumber and hire a roofer or call a locksmith, this is just a modernization of that. So the Board of Pharmacy asked to put this bill forward, and what this does is it delineates it takes out of the pharmacist in charge and it puts in a permit holder. So what we've done now is where their pharmacist in charge was responsible for certain activities and certain responsibilities, we've rewritten the bill, rewritten 318, and put that responsibility under the permit holder, which essentially would be the owner or that designated person within the bill. This has come again, this has been, when we put this bill together, we brought in a number of stakeholders. This has been supported, like I said, by the New Hampshire Board of Pharmacy. I think you're going to hear from the New Hampshire Pharmacists Association, or at least they've signed in. New Hampshire Hospital Association, the chain pharmacists have supported this. CVS has supported this. This has been run by some of the folks down at Amazon. It's a wildly supported concept. It's a modern concept. And it's one that I think reflects the current state of pharmacy in the times. So with that, I would be happy to answer any questions that the committee may have.
So this bill probably should have gone to ED&A and normally would have gone to ED&A, but I think that they had so many bills and they knew we were doing pharmacy bills. So
You guys love pharmacy now.
we're getting a little more boned up on the pharmacy. So,
Sure.
but I don't think we have any particular questions.
Great.
It's very straightforward.
Thank you.
Good job. Okay. Next is, let's see, I don't have any. Oh, Gary Merchant. It's in support of the bill.
I have written testimony, which I won't read to you. I'll leave that to your pleasure sometime this evening or some other time. I also have a written testimony from an attorney who's also a pharmacist, Richard Fredette, in support of the bill as well. Hold on one second, please. For the record, my name is Gary Merchant. I'm a representative representing Claremont and Croydon, which is Sullivan County District 6. Prior to serving in the House, I served on the New Hampshire Board of Pharmacy, along with Representative Rochford for a period of time. Of the 10 years, the last 2 was serving as the president of the board. This is really a simple bill. I'll just get it down to the brass tacks. We need to find a way to align accountability with authority. He who has the authority should be accountable. As Representative Rochford said, it's a relic from the past. Back in the 50s and 60s, when a lot of this came about, the owner of the pharmacy was most likely the pick. So you had alignment between authority and responsibility and accountability. However, over the years, as independent pharmacies were acquired by corporate America, as corporate America expanded locations, that alignment has been eroded to the point today where the pharmacist in charge still retains all the accountability to the board with extremely little, if any, authority. They don't decide on the staffing. They don't decide upon the drugs, what's stored in the pharmacy. They really have very little authority outside of showing up to work and doing what they're supposed to do. I'll give you an example, which is what prompted a lot of this. We had a case here in New Hampshire, which a pharmacist in charge in a hospital was held accountable. Makes sense. However, we have documentation that they sent requests to senior leadership asking for resources so that the issue that arose would not arise. They were not supplied with the resources. But the way the law is written, there is no authority by the board to hold a permit holder accountable because they don't have accountability. They only have authority. So what this bill fundamentally does is goes back to aligning accountability with responsibility. Number two, if you look at the statute today, the pharmacist in charge is not only accountable for themselves, they're accountable for all the pharmacists working within the pharmacy. Why would one pharmacist be accountable over another pharmacist, how they practice? You wouldn't hold a physician accountable for another physician. You wouldn't hold a nurse accountable for what another nurse does. So why do we do that with pharmacy? So all I'm asking in support of the bill is for you folks to think, how do we align fundamentally? If you have the authority, you have the accountability. And I'll submit my testimony written, as well as one from Rick Burdett. May I approach?
Great.
May I approach?
Yep, thank you. Thanks. Nice seeing you. Okay, do we have any questions? I think it's pretty straightforward. This is bringing the statute up to up to the current times. Yeah, sorry. Okay, thank you very much. Kathy Bizarro Thunberg from the Hospital Association. So nice to see you again.
Nice to see you. Good afternoon, Mr. Chairman and members of the committee. My name is Kathy Bizarro Thunberg. I'm the Executive Vice President, New Hampshire Hospital Association. We represent all 26 acute care hospitals and all specialty hospitals in New Hampshire. We are in full support of House Bill 426. And as already mentioned, the alignment between a permit holder and allowing licensees to focus on their scope of practice is really the crux of this bill. Under the current statutory framework, all responsibilities of a pharmacy are assigned to a pharmacist in charge, which includes the operations, their own scope of practice, and those that work in the pharmacy. Many times, as already stated by Representative Rochefort and Merchant, those operational decisions about how to run a pharmacy are made at a different level, not themselves. But unfortunately, the Board of Pharmacy holds the pick solely responsible for everything. We truly believe that properly aligning pharmacy operations as the responsibility of the permit holder and allowing the individual professionals to be responsible for their own actions and their scope of practice is the most appropriate way to structure pharmacy and pharmacy regulations. I really do urge you to support this bill. Happy to answer any questions.
Thank you very much.
All right, thank you. I do have written testimony, which I will share.
Written testimony is great.
Thank you.
Got one more card left. Robert Thrall, New Hampshire Society of Health System Pharmacists. Just a pharmacist won't go away. No, right? Hi.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name's Bob Terrio. I'm the legislative chair of the New Hampshire Society of Health Systems Pharmacists. So we're a professional organization that supports the professional interests of pharmacists in all practice settings, hospitals, community pharmacy, and clinics. And I'm here to support House Bill 426. I think the Representative Rochefort and Merchant and Kathy have framed the issue well. The PIC language, I've been a pharmacist for over 40 years, and the PIC language was around when I became a pharmacist. And so it is decades old and archaic. Most pharmacies are either managed or owned by a district or regional or corporate level. And most of the PICs do not report to a pharmacist. I'm actually also the director of pharmacy and a PIC at Wentworth Douglas Hospital. And I report to a chief nursing officer, and our hospital is part of a larger enterprise system, so oftentimes decisions are made outside of even our hospital scope. So as you can see, the decision-making and my authority and responsibility is broad-ranging, and I don't always have the control that I have. As there was a case, as Representative Merchant mentioned, of a controlled substance issue in the state of New Hampshire, and that pharmacist in charge was held accountable. And what came out in part was the organization had not renewed a contract for diversion monitoring software. And again, that pharmacist was held accountable for that. I don't know if you're aware of Chapter 797, where sterile compounding, most sterile compounding has to be done in clean rooms. Clean rooms require large sums of money for HVACs, and to build a clean room can be in the millions of money for HVACs, and to build a clean room can be in the millions of dollars. And if I violate a clean room statute, it's my livelihood. So bottom line, I think what this bill does is put the employer-employee relationship in line, puts the accountability for the permit holder where it should be, and the accountability for my license where it should be. So in essence, I could lose my livelihood to be practiced as a pharmacist if I violated a PIC, or if my organization violated a PIC responsibility. I did draft written testimony, and I will hand that to you. And if you have any questions, I'm happy to field them. Thank you.
Thank you. All right, having no more cards, I would say the blue sheet, we have everybody is in support, including CVS Health, New Hampshire Chain Drug Stores, and the New Hampshire Pharmacists Association. So, we're all good. I will close the public hearing on 426. And now I go to our last bill of the day, House Bill 303, relative to insurance coverage for pain management services. And Representative Nagel? Is Representative Nagel here? Oh, there you are. Okay.
Mr. Chairman, I have a written statement I would like to share.
That would be wonderful.
All right.
Makes the clerk very happy. Always one more. Good afternoon.
Ready?
Yep.
Okay. Thank you, Mr. Chairman, and thank you for the committee for our time. I'd like to spend a little bit of time introducing the bill, introducing myself, and giving you some suggestions on where we should go from here. And thank you very much for your time. I've been a practicing physician in New Hampshire now for roughly 33 years. I started my career at Easter Seals. I moved on to Concord Orthopedics. My specialty is physical medicine and rehabilitation. I work with people with complex disabilities. All the disabilities I deal with involve some element of pain, so I become a pain management specialist, somewhat by default, somewhat by design. About 30 years ago, I realized that we as a society don't treat these people very well. We stigmatize them, and so I became involved in advocacy, first for people with post-concussive syndrome, and then people with chronic pain. And that's been my passion for the last 30 years. As part of that, I initiated and helped write the first opioid prescribing rules for the state. I actually helped create the first, the Acupuncture Practice Act as well. I also started two nonprofits, both devoted to increasing access to therapies and supporting the needs of people in pain. About 7 years ago, I was asked by the NFL Players Association to chair their pain management committee, and I've done that for that period of time, and I'm one of the lead authors on their best practices guide for how we manage pain. Most importantly, out of frustration, I wrote a book called Needless Suffering, How Society Fails Those with Chronic Pain. It was published 7 years ago, and it's one of those yeah, duh books that basically tells us what we're doing right, what we're doing wrong, and how through creative public policy we can do a lot better to help the people in need. And basically, it's because of needless suffering that I wrote this bill. And I would be lying if I told you that I alone wrote this bill. It's a collaborative effort. If you look on page 2, you list all the organizations that sponsor this bill. I'm involved with most of these. The one I want to draw your attention to is the Alliance to Advance Comprehensive Integrative Pain Management. That's a group out of Kansas City, and they represent over 92 national organizations, including healthcare providers, patient advocacy groups, the Department of Defense, the VA, and believe it or not, insurers as well. We've understood we in this country have understood since the 1980s that pain management is best done in a multimodal integrative manner. What that means is that somebody's running the show and that we provide a variety of modalities simultaneously to help maximize outcome in pain management. If you believe in Eastern philosophy, which I do, that is written as far as 220 BC. It would be wonderful if that's what we do, but it's not what we do. Basically, what we do in our culture is we pay for pills and procedures, and because of that, that's what we provide patients. And unfortunately, it's not a very good way of going about things. There's nothing integrative about it. None of these modalities really has shown any long-term benefit. And it's a huge problem because in my world, humbly and somewhat grandiosely, I see my role as standing up for the rights of 66 million Americans who suffer from chronic pain. 1.5 million people are in hospice at any point in their life. The tens of millions of people that suffer moderate to severe acute pain. And also there's about 50 million post-op patients per year. All these people require some element of pain management, and I don't think that we're doing a very good job with that. So the system's not working. And as of 2011, the Institute of Medicine came up with a number that we quote over and over again. It's probably a lot higher now, but that costs our society in lost productivity, medical costs, et cetera, $650 million a year. So the point is that we really need to do better. And what we've created for ourselves are a number of crises. Number one, we have a crisis in over-opioid prescription. We simultaneously have a crisis in under-opioid prescription. We have an epidemic of costly procedures. We have a crisis of costly, inefficient health care, particularly those who suffer from complex disabilities. We have a crisis of dependency and lack of individual empowerment. And that was a big issue in our Committee on Health and Human Services the other day, trying to fix that problem. It also fuels the mental health crises. The likelihood a person with chronic pain will successfully commit suicide is 3 times that of the normal population. Nobody seems to care about that, and that really bothers me a lot. It's something that's really important. 70% of people with chronic pain will have comorbid depression and anxiety disorders and other things that are very treatable that we don't treat or we don't help them with. To address these issues, I'm going to read from all, no, I'm just kidding. To address these issues, the Center for Disease Control and the Department of Health and Human Services separately created best practices guide for pain management. The CDC guide on opioid prescribing came out in 2016, was revised a couple months ago. The HHS guide came out in 2019. I was honored to be part of all of those. Mostly with commentary, but the big thing that came out of these is, yeah, opioids have value, but we need to watch them, but also that we need to increase access to a variety of therapies that we refer to as alternative therapies, including manual therapies, restorative therapies, which means exercise of some sort, chiropractic, physical therapy, we neglect the psychological aspects of managing pain way too often, and they're extremely critical in managing people with depression, how to reform the way they look at their pain, things like that. Um, also, Eastern forms of exercise are really amazing. Like I had a 90-year-old lady come in to see me today that all I needed to do to improve her balance was to get her in a Tai Chi program. And something very simple like that. And we don't do that. And so what happens? We give her gabapentin, she gets dizzy, she falls, and now she's got a broken hip, and a year later she's dead. I mean, that's just totally not acceptable, but that is the way we manage pain. I'm not going to go over the details of HB 303. I'll leave that up to you. But what I wanted to say, this is what it does do. And I'm going to say again, this is a collaborative effort with a lot of people all over the country. I'm not that legislatively smart. These people are much smarter than I am. And we worked on this together, which is really exciting. And these are people from all different disciplines. But what it does is increases access to a broad array of cost-effective, evidence-based therapies provided by licensed practitioners. And we've already went over the different modalities involved. It empowers individuals, which is incredibly important, with the skills that they need to control their lives. It gives the potential, which is really important, to prevent chronic pain, because right now we cannot do that, and we do not do that, and we do not do a good job of that. Also, we've had a lot of discussions with insurers about this issue, and they're exciting. I really like talking to them. I've learned an awful lot about their side of the world. But it creates some level of transparency, because what they'll say is a lot of these services are offered, and I don't disagree with that, but they're not offered in a transparent way. We, the providers, don't see that. Like, if they have this insurance, what can I do for this person, that person, or the other person? And that transparency issue is critical. It transitions away from expensive pills and procedures that have limited efficacy. And you're listening to a hypocrite say this because I am an interventional pain specialist. God bless me, everyone. It does not eliminate allopathic therapies. They still have their value, but they need to be part of whole person care. So as a part of the Comprehensive Addiction Recovery Act of 2016, the VA was charged to create a charter program that would look at this to see, can this work? And I just talked to Ben Kligler from the VA today to get their outcome data on that, to make sure that I wasn't missing something. And Ben told me, and it's also published data so you can see this. Number one, the people in their program that provided access to these services, and when I did visit the VA here in Manchester, they do have access to chiropractic, acupuncture, mindfulness meditation, all that stuff. They found out there's a 38% reduction in opioid use. And while I think some people need opioids, every patient I've ever been on who has on them would rather not be on them. So we gave them an alternative strategy to manage their pain. 30% reduction in interventional stuff, that's where you save the money. If I'm not doing a $3,500 injection and this person can manage their pain without relying on me, that's what I want. I want to go out of business. That would be the best for me. I know you're a Commerce Committee and you're supposed to promote business. I want to go out of business. Less anxiety, depression, less medication use, especially interestingly for psych meds, and improved quality of life. What I want to close by saying, I want to share a story. I run a nonprofit. We're looking at a whole life, whole person approach to athletic participation. Pain is a huge issue that we deal with. I did a focus group with a bunch of NFL players who are on injured reserve. And the first question we asked them, which I already knew the name of, the answer to was, do you trust your doctor? And the answer was an expletive no, very loud. And then the one guy looked at me, he was 24 years old, said, I don't trust any doctor. And it wasn't based on just him, it was his family experience dealing with pain and other related issues. And then I said to him, I go, why is that? He goes, because all they're interested in is giving me a pill or a procedure that I know isn't going to help me. And they're more interested in their bottom line than they are in me. And then I looked at him, well, then what do you do? And then without being at all, I'm going to brag a little bit here, but anyways, without prompting at all, he basically outlined HB 303, all the modalities that he uses to manage his pain. He is an NFL player. Getting access to care is not an issue, but I've talked to retired players where we did focus groups as well, and they said it's a shock when they leave that locker room for the last time and find out that they don't have access to these things that they've relied on their entire career to function. This is an opportunity for us. We have been charged by patients, families, providers, governments, agencies, et cetera, to provide responsible, patient-centered, integrative, interdisciplinary, cost-effective, broad-based care. That's a run-on sentence for those who suffer and who too needlessly from chronic pain. This bill was developed in collaboration with thoughtful, mindful people who I'm honored to represent, many of whom are here behind me today. As far as I'm concerned, if the HHS and the CDC have anything to do with it, we as providers are ready for this, and we would really like the insurers to assist us in that process. And I'll be happy to take any questions.
Yes, Representative Spear.
But I have two questions.
I have all day.
This one is to get an opinion. First of all, it seems like we're attacking the problem kind of like from the bottom instead of from the top. And as a result of that, since so many people in my age group, and I don't want to say yours, but it is mine,
We might be closer than you think.
we're not going to get any help out of Medicare or Medicaid. We're just not, so whatever laws we pass here, people in my age group and on, we're not going to get anything from it. The second, but my question then is this, you mentioned licensed practitioners.
Yes.
So I looked that up. Based on the practitioners that you talk about, yoga, qigong, and a few other things, they are not licensed.
That is somewhat correct, but this is how I would qualify that. I would take yoga out of this. That was shouldn't have been in there.
Oh, okay.
The nice thing about yoga, though, is it's available to anybody. But I will tell you, I did talk to a Hindu yoga master. I don't know what they officially call themselves. And I asked him, what kind of yoga do you recommend for back pain? And he said, I don't. We have a really strange idea of what yoga is in the United States. It's not really what they think of in Hindu culture. Some of the movement patterns really aren't good for those type of people, but we've modified it a lot. But you can go online. There's all sorts of access to it. It's not a big deal to access yoga. Tai Chi, maybe, but Qigong and things like that, almost all the people I've known that do Qigong were instructed by acupuncturists who are licensed, and they would do that as part of their therapy.
The acupuncturists are, but they themselves are not. Anybody can hang a shingle out there and say, I'm going to teach this stuff.
Oh, the
In the
Qigong.
state of New Hampshire.
Say that again.
In the
Explain
state
that
of
to
New
me.
Hampshire, you don't need a license or a certification of
For-
any kind.
For
Qigong.
Oh, you're correct. You're correct. And-
Acupuncture, you certainly do.
Mhm.
There's
I
no
thought
doubt
that's
about
what you were
that.
saying. I'm sorry.
No, Qigong you don't, Tai Chi you don't, and yoga you don't. That's where I'm having a little bit of a problem trying to, as a customer, let's say, finding someone legitimate. And how would an insurance company find someone legitimate because they're responsible for supplying these people?
I could respond to that in another way. When we designed this bill, I've been involved with insurers and talking about this for a long time, and I realize we're very much on different sides of this issue, but I do think it's important societally to come together on these issues. So I will say that this is a compromise bill. It's nowhere near what I would like, but it is what I think we should have as a bare minimum.
What other states? I assume this is model legislation that's just being presented to all the states, or?
Cindy Steinberg from the U.S. Pain Foundation worked on this bill with me, and she wrote a somewhat similar legislation in Massachusetts. There's other bills in other states. There's a project going on in Vermont right now that the Alliance to Advance, and the VA is very much involved in creating models of care like that. I will tell you, I've been here for 33 years. I've always believed in integrative care, whether it was handling stroke, spinal cord injury, pain, whatever. When I started out, we actually created this model by ourselves with no oversight. There's no umbrella organization. We didn't call ourselves God's Gift to Pain Management or something. We didn't have a name. We just did it. And so what I've tried to do is to replicate that model, and I'm really frustrated by barriers getting in our ways. Well, this hospital doesn't want to work with that hospital, with that private insurer. It's a crazy system. If we're going to have a market-based system, we need to have barriers that don't exist so that we can collaborate with each other. And part of this bill is also to break down those barriers as well. am I allowed to answer her other question that she comment?
Of course.
Okay. I'm sorry, I can't read that far because I am older than you think. We do have our healthcare is wrong. It's a pyramid like that. Read my book. There's an entire chapter on redoing the entire healthcare system that focuses on management of problems, not proceduralizing it. Fragmentation is a huge problem in our healthcare system, and it's because we're like that, not like that.
Okay, so Representative Sullivan, sure, go ahead.
Thank you, Mr. Chairman. Yeah, I just have one quick question, which is, if we already pay for a lot of these, so at least some of these things that we pay for, like physical therapy and chiropractor care, that's generally considered normally covered by insurance companies. So what is the resistance to it now? Specifically, if what you say is true, that they could save money. Like you said, you could get this done for whatever versus a $3,500 shot. Seems like a no-brainer. So there's got to be a good reason why we haven't moved in this direction organically.
I think I would have to defer that question to the insurers. I mean, you all know, I mean, I sat down and made a Venn diagram about our entire healthcare system, about how all these little pieces fit into each other. Because there's this saying, for every complex problem, social problem, there's a solution that's neat, simple, and wrong. So I was trying to figure out, like, well, how all these things fit together. And to answer that question, there's no simple answer to that, which is unfortunate. One of the things that I've observed in all the years that I've been here, number one, is 30 years ago when we wanted to communicate, we actually picked up a telephone. We don't do that anymore, which is a huge problem in medicine because we don't communicate anymore. But the other thing is that when we started out, chiropractors would be allowed to have almost an unendable number of visits with people. And then it was 20 visits. Then it was 12 visits. Then some insurers it's 6 visits. Then other visits, none. Then others, you need to have prior authorization. Then we'll allow you 5 visits, but after 5, you have to submit another thing. And then when you do that at extensive cost, then you find out 3 months later, you've been approved to do some more. And by that time, anything you started with is lost. And I had to deal with that issue with acupuncture. It's not a good system. And the crazy thing that we had talked about earlier today is we don't pay for psych services well. I think we all know that mental health in the states, and it's not just in New Hampshire, it's all the country, is a problem. Access to care. All these things are important. 20 visits is really nothing. I don't know why. If you can answer it, I'd be happy to hear. That was a very long answer for an I don't know.
So we will have a subcommittee, and yes, I can tell you why when we do the subcommittee. Okay, Representative Spear.
We touched on it, but you didn't answer it, and maybe you don't know the answer, but there were 3, the yoga, the Qigong, and the Tai Chi are not licensed. So how would even asking you as a personal question, how would I even find somebody, since I don't know who's qualified and anybody can hang up a shingle?
I mean, I tend to have my little network of referral people that I trust. But you're right. I mean, even an acupuncturist, I mean, you can go to the board of licensure, or a doctor even for that matter. There's some I trust, some I don't trust.
But that's certainly true.
Yeah.
But then I have a recourse. With these other folks, I don't. And so I'm wondering how you would expect an insurance company to be able to provide them.
My answer to
Who
that
would they
is-
go to?
Yeah, my answer is that those things should not have been in that bill, so I would probably amend it to take those out. How's that? I mean,
it's a work in progress.
Yeah, in an ideal world, we have the same issue with personal trainers. Exercise and restorative care is really important. It's probably the most important of anything in this bill. We didn't include personal trainers because there's no licensure. And to be honest, for the same reason, those 3 things should not have been in there for that same reason.
But we've had that bill in the past.
What's that?
We've had that bill in the past.
Yeah,
To
for
mandate
personal trainers?
Trainers, yes.
I'm sorry, I missed that.
We've had that legislation to mandate a third-party insurance reimbursement for
personal trainers.
For athletic trainers.
Yeah, that's an interesting.
Representative Ammon.
Thank you, Mr. Chair. Thank you for your testimony.
Thank you.
I just have a question of clarification on page. What page is this?
Is this my
page 1 of
testimony?
the bill? Of the bill.
Of the bill.
Yeah. and it's line 20.
You know, go ahead and say it. My
Oh,
bill
yeah.
doesn't have the lines on it. I'm
Oh, it
sorry.
doesn't. It's Roman numeral 2 under section 1. But it says, shall provide for at least 20 visits and shall include coverage for coordination of pain management services during the plan year. And then it says for each of the preceding pain management services to manage pain. So preceding would be that list that we've been talking about.
Yes.
So the way I read this is one interpretation could be it could mandate 20 visits for each of those different, which could be, I don't know, 200, 300 different visits. Is that how you meant?
That's not the intent. The
Okay.
intent was 20 total.
Okay.
Be honest, if I have a wish list, it would be 20 for each. No. I'm happy to change it.
Okay. Thank you very much. So, Representative Marapudi, who put in a bill last year. Yes, you're a rep, so you get first up. Now, last year your bill was yoga. Do we have yoga? Yes.
That's how we met.
There we go.
Thank you. I'm Representative Manji Puri from Nashua, Hillsborough 11. This is the third term that this kind of bill, with not my name on it this time, has appeared. So basically what this bill is attempting to do is turn the pyramid of healthcare system upside down. If you all know how the nutrition thing was pyramid with, bottom was grains and now it's upside down, do the protein on top and fat. So basically our current healthcare system is disease-based and treating the disease. So this attempts to integrative medicine, looking at a person, not my left hand, my right hand, the specialist, my right eye, go to the left eye specialist to treat your left eye problem, not the right eye kind of thing. But this is looking at a whole person who's dealing with pain and preventive early intervention, a holistic approach to what's available instead of doing a piecemeal. So I've tried in several different forms. First term, I introduced it to Health and Human Services and committee, and also worked with one of the health insurance folks, provider, I won't name the name, to do a pilot, how it can be impactful. So it's different. It's not very different, but if you look at human beings and what we are treating, this makes a lot of sense. So I'll give you an example. My husband has a chronic back pain, and he has gone for multiple MRIs, and he's claustrophobic, so they have to put him under to put him through CT scan or MRI, and he dreads that. And so the diagnosis is, okay, you do not have any joint issue. You do not have any tumor or anything, thank goodness, but they are not able to pinpoint what it is. So they can't do surgery. And other than taking medication, he says, no, I don't want to take painkillers extended period of time. And so he has to function. He's a public school teacher, and he has to function as an individual. So finally, he started going, we both are yoga practitioners, and, we come from a place where yoga capital of the world. And so this whole integrated approach. It has taken in the manipulative osteopathic manipulation. He fixed the problem in 2 settings, and to maintain it in that way was yoga, physical therapy, and chiropractor. This is what took 5 years of going through. We had a good insurance, thank goodness, and we could do that. And the amount of money we spent on that, if we had started this intuitively say, okay, can we do this? But, it wasn't available. It's not a mainstream. So these are, this integrative medicine in the Eastern medicine, it is part of practice, everyday practice. How do I license and make it quantitative, billable unit is a challenge. And I'm persisting with that. So I give all kudos to Representative Nagel, because he and I have been sitting on this committee for 8 years now. So I would encourage, if we can do a subcommittee, I can give you a lot of data on, models that can work. So I'm still working on that to get some funding to do a pilot and show some significant evidence base. It's like chicken or the egg come first. What comes first? Unless you have a pilot study or pilot to do it, you can't show an evidence. All you have is anecdotal. So prevention is, an ounce of prevention is better than a pound of cure. It was 100 years ago, it's today, and it will be tomorrow. Thank you.
We do have a question. Representative Ammon has a question.
Hi, Representative Manjapudi. You may remember you and I were seatmates for 4 years in the House. So, well, good to see you. The previous speaker, the prime sponsor, said he would consider removing yoga, qigong, and tai chi from the bill. Is that your position?
No, what I would say is because there is no clear path of licensing therapeutic yoga. Okay, there are therapeutic yoga providers that do exist, but there is no board. But there are other states or other places that have done it, so I can get you some information on that.
Okay, thank you.
Great, thank you very much. Okay. New Hampshire Medical Society. Okay, I'll keep her around here. So next up I have here is Amy Odell Wilson from the New Hampshire Acupuncture Asian Medicine Association.
Good afternoon. Thank you for allowing me to speak. My name is Amy Odell Wilson. I'm a licensed acupuncturist and also a Qigong instructor. I'm the vice president of the New Hampshire Acupuncture and Asian Medicine Society, and we do stand in support of this bill, HB 303. We're here today because we are pain care specialists, and it is our collective experience that acupuncture, Qigong, and Tai Chi, when used together with other pain management protocols, improve outcomes. Many of those have already been mentioned, but I want you to just reiterate that every protocol, no matter what it is, for pain management has its shortcomings. And when it's used in conjunction with other therapies, we're able to reduce or avoid medications altogether. We reduce negative side effects. We speed up recovery. We correct the root cause. and we reduce anxiety and depression. Acupuncture is underutilized. Less than 9% of the insured actually have access. And listening to the others speak, going off script a little bit to address some of the things that have been brought up. Oh, and also, quick pause. We did email our position last night, and this is a hard copy, but also connected to it are some research bullets. I know your time is very valuable and you don't always have the time to dig into some points. I'll let that pass around and speak to this specifically about Qigong that was raised. I believe that although Qigong in New Hampshire is not a licensed criteria, acupuncturists who are licensed were trained at school to practice it. And currently, if we're reimbursed by insurance for acupuncture, we're not reimbursed for Qigong. And yet it's medical protocol. And so in thinking about that, I would ask that you don't take Qigong out of this bill, but in fact, you would allow acupuncturists who are trained to be reimbursed for this service. Also Tai Chi, if that's their expertise. And then if you draw your attention to the second to last paragraph of the first page, also addressing the question that people over 65 who are on Medicare don't have access to acupuncture. It's coming. As of December, you might not be aware that the No Pain Act was passed at the federal level. It'll become effective in 2025. And this will mandate at the federal level in Medicare that non-pharmaceutical and non-addictive therapies are covered by insurers. And then if you flip to the back to the second research bullet that I have there, you were asking if there's other models out there that this has happened. Dr. Nagel talked about some in the state, but there are actually 5 in the world that have been looked at. And 2 points of that, you'll see that not only the UK, but Germany, Switzerland, China, and the US have models for this, but also in their research, they noticed that the economics can rarely be the only thing that's considered. We really have to look at the long-term outcomes of this. And that's because it takes such a long time to fully understand the health economics. And in the meantime, people aren't getting the care they need. Also, you may or may not know that Medicare currently covers acupuncture. However, it's not really convenient since acupuncturists are not Medicare providers. And so under the current system, it covers low back injury, if it's insidious, if the pain has been there for more than 12 weeks, and if you're seen by a medical doctor, which we're not under the license of a medical doctor, but the only way an acupuncturist can get reimbursement for Medicare at this time is if the medical doctor gets paid and then pays the acupuncturist. I don't know any system or any medical doctor who's going to go through that. So yes, it's out there, but only a medical doctor who performs acupuncture at this time are the ones who can get reimbursed by Medicare. That's hopefully changing. We do have a bill that will be in the House of Representatives this year. And the U.S. House, yes, the federal House. And the last thing just to put out there, maybe one of the most important parts of this is that when insurance recognizes the importance of these modalities, media grabs a hold of it, more people become aware of it, more people trust it, more people will find access to it, and then it'll spread, and then you'll see the economic results. And I'll take any questions.
Representative Calabro.
Thank you, Chairman.
My question is, this protocol that you speak about, that uses several modalities of treatment, if we were to permit, say, licensed acupuncture, but omit the others, is that going to cause a serious hardship for the treatment plans that you have organized and have arranged that you found effective?
So I can speak to the way I work and patients that I work with. And I'll tell you two specific stories, but very short. When people have access to acupuncture, qigong, physical therapy, massage, yoga, it's a wraparound service, and people find the care that they need because no pain is exactly the same. No person is exactly the same, and what they're capable of is not the same. So in two instances, really quickly, I work primarily with the geriatric the senior population. Probably the average age of my patients is 75. I have one individual, 80 years old. He's been on gabapentin for neuropathy, pain for over 30 years. And the problem with that is it causes dizziness. And all of you know that dizziness is a high risk for falls. And when you have a fall and you're 80 years old, you're part of a medical system, and that's expensive. So his quest has been to reduce his dizziness by getting off of gabapentin. Over the past year, he's received regular acupuncture. He's in my Qigong class, and he's gone from 900 milligrams of gabapentin down to 0 in a year and a half. He's no longer dizzy. Because of Qigong, his balance has improved, and because he's off gabapentin, he's no longer dizzy. So his quality of life has soared. Another person is 70 years old. She was diagnosed with insidious nerve pain and spasticity. She was falling every single day and walking with 2 walking sticks. She ran into roadblocks. She started to see me, started my Qigong class. She only walks with a cane on occasion. Her doctor has recently just told her that if it weren't for Qigong and acupuncture, she would be in a wheelchair today. That's expensive.
So is there any insurance company or any employer that's now reimbursing, for?
There are insurance companies that do reimburse, Blue Cross and Blue Shield, Cigna. The interesting thing about that is because they're not mandated, those are riders, and depending on the employer, they choose or choose not to have the acupuncture rider or any other rider.
Yeah,
So
I wouldn't
it's-
call it a rider. What that is, those are large employers that are self-insured, so they have decided to add that to their plans.
Okay, so it's not a mandate, so people are choosing, not
Right.
the individual who's being insured, but a bigger organization is
Right.
choosing whether someone has access or
So
not.
some large employers are doing it. You have,
Yes, and then on a personal experience, Cigna was in the state a couple of years back. They were trying to get more acupuncturists involved in the plan, and yet they were offering different acupuncturists different reimbursements.
different rates.
And so I can't say that a lot of acupuncturists signed on to that because one, the reimbursement was so low. And then also the fact that they were choosing to give different people different reimbursements doesn't sit well.
Take note, George. Okay.
Are there any other questions?
Thank you very much.
Thank you.
Okay, so let's change our pace a little bit and hear from the insurance companies. So Heidi, why don't you, as the representative of them all?
Good afternoon, Mr. Chairman and members of the committee. For the record, my name is Heidi Kroll. I work at Gallagher, Callahan, and Gartrell, and I represent AHIP, which is America's Health Insurance Plans. We are the trade association for the health insurance carriers here in New Hampshire. Thank you very much for the opportunity to testify. As you might imagine, we are opposed to House Bill 303 for reasons which I will explain, and we would respectfully request that you find this bill inexpedient to legislate. First and foremost, we do think that the bill is unnecessary. We are not aware of any other state where this extremely broad set of mandates exists. Carriers in New Hampshire already do offer a variety of health plans that cover a range of treatment alternatives to opioids, both medications as well as alternative medications to opioids, as well as non-medication options. And a variety of informational and educational resources and materials as well, both to members and to providers. But as you might imagine, carriers offer different plans with different covered benefits, which result in different premiums. And so members can choose the plan that best meets their needs and their budgets. We did a little... We've had a number of bills, and I have that later in my testimony. We've had a number of bills over the years on this topic. Most recently, there was an ad hoc work group that was working on this over the summer as a result of a piece of legislation last year, and we kind of did a little survey of our active members here. So chiropractic services, physical therapy, occupational therapy, and TENS units seem to be universally covered under AHIP members' standard plans. Coverage for acupuncture and gym memberships do vary by plan. Plans typically do not cover massage outside of a covered chiropractic PT or OT visit. Meditation is not covered, but it is included in the carrier's health and wellness resources. And I did bring a copy for myself, but if you go onto any of the plan's websites, you will find that they have meditation and mindfulness resources that are made available to members and to the public as well, including podcasts and things like that. There's also a list, at least I found one on Harvard Pilgrim's website, and it was many, many pages long about the alternative medications to opioids that they cover as well. And of course, a variety of behavioral health services. As Representative Ammond kind of picked up on, House Bill 303 lists approximately, by my count, about 18 services, which are all seem to be qualified by the phrase including but not limited to, indicating that there are an unknown number of other services beyond those listed. And we did have the same concern that if you were to mandate coverage for a minimum of 20 visits for each of the services listed as well as those not listed, but even if you try to narrow that down, if you were to do this across every single health plan offered by carriers, that would have upward pressure on the premiums for everyone. And the fiscal note does echo that point. It's also important to note because the bill looks to impose new mandates in the individual market that exceed the state's benchmark plan, the state would also face a new financial
We would have to pay
liability.
that,
Yeah. So there were some questions earlier about this. It is important to remember that the bill proposes to impose new mandates only on the fully insured individual, small group, and large group markets, which account for less than 25% of New Hampshire's market. So in addition to the fully insured, there's also self-funded employer coverage, there's Medicare, Medicaid, military coverage, people covered by out-of-state employers, so that would not be impacted by this set of mandates, and of course the uninsured. So we're really talking about putting potentially some upward pressure on premiums paid by New Hampshire citizens who are in the individual market or premiums paid by New Hampshire's small to mid-size employers. Another point is that covered services from the plan's perspective should always be evidence-based services. And they're, based on clinical and scientific
That's
evidence.
the key word, evidence-based.
Right. And so there's a concern that this bill would override that important criteria. And as some of you may know, carriers do have independent review boards. They're continually reviewing evidence and efficacy around medications and treatments and services, and they update their coverage accordingly. You've also touched upon this. Another concern we had is that there's mandates for coverage of services that would not be provided by licensed and credentialed clinical providers. And as we mentioned, no medical licensing or credentialing process for things like yoga, Qigong, Tai Chi, aquatic exercise, meditation training, things like that. And carriers' networks are obviously a fundamental aspect of insurance coverage, including the network adequacy, statutory licensing and credentialing requirements, quality of care standards, as you might recognize. Our stamp of approval on providers in the network means something to the members, and of course, the negotiated reimbursement rates. And as I mentioned when I first started, we have had several bills in the past, as well as actually 2 others this session, dealing with these similar issues. The 2 that are in this session actually are how we're referred to House HHS. One is relative to alternatives to opioids. It has 5 sections. The first one is not an insurance mandate, but the other 4 of 5 are, and they look very, very similar to this bill. It's sponsored by Representative Lundgren, but Representative Nagel is also a co-sponsor of that. So just wanted to make you aware of that bill. Again, that was House Bill 554. It does have an FN on it as well. There's another bill, House Bill 66, establishing a commission to study non-pharmacological treatment options for patients with chronic pain. That was also sent to House HHS, same 2 sponsors as House Bill 303 has. That was an outcome of House Bill 247 from last year relative to treatment alternative to opioids. And as I mentioned, that was actually a 2021 bill. I think it was retained into 2022. And they created an ad hoc group, just kind of people willing to get together over the summer, which led to the idea of having a commission on this. We've had 2 others, I think, or 3 others in the past. House Bill 1464 from the 2019 session, that was relative to insurance coverage of yoga. That was not recommended for future legislation by this committee, I believe, on a vote of 14-1. And that was when the Democrats were in the majority. The current chairman was actually not chairman at the time. SB 708 relative to treatment alternative to opioids, that died on the table. And in 2019, House Bill 610, again, relative to treatment alternative to opioids, that was ITL'd by House HHS actually on a 22-0 vote. So we've covered this issue, lots of times in the past. And I think for the reasons that I've outlined here today, it's just given people some pause and some heartburn, I guess, about going with such a broad mandate. So I'm happy to answer any questions, and I know there
So
are other
given
carriers.
that this bill only affects the small group, we know we would have to take the individual piece out because the state's not going to cover that. So if it only the small group, is there any benefit in here that the small group, I guess I'm thinking, we know the chiropractor is covered up to 12 visits a year. Is there anything else, is like acupuncture, is there anything that is in the small group market that someone could get that in the small group market today?
So the acupuncture coverage varied by plan when we surveyed Harvard Pilgrim, Anthem, and Cigna. And I do know, I think it was referenced by the prior speaker, but at least in the case of one carrier, did, and maybe more, did a full sweep of trying to get acupuncturists to join the network last summer, I think, and struggled with that. So
Finding providers, right?
but it varies by plan. So
Okay,
not every.
So technically, there's 2 things now that's, one is the chiropractic, which we did mandate, the 12 visits. And then the other is, but the acupuncture is now voluntarily.
It's in some plans and it's not in others. So if it's an important service for somebody that, from an employer perspective, it's an option.
Because I know in the past, I think once with natural paths, I did May. Is May still in the statute, or did that get switched to shall? Is it May for natural path to be your primary care physician? Is that still in the statute?
would have to double check. I don't recall it being changed
Right.
from May, but I. would
So
need
that
to
is something we have done in the past, is put in may rather than shall. And we did that for
Okay.
natural paths.
That's a possible option.
Right. Okay. Thank you very much.
Thank you.
Okay, James Pamplin from Chiropractic Association. Good afternoon.
Good afternoon. Hello. I'd like to thank the committee for allowing me to testify on behalf of the New Hampshire Chiropractic Association, and I am in favor of House Bill 303. My name is James Pamplin. I've been a practicing chiropractor for over 20 years in New Hampshire. During that time, I'm also a member of the board of the New Hampshire Chiropractic Association. During my 20 years practicing, I have unfortunately seen a gradual decline in insurance benefits for chiropractic care. This has resulted in my practice canceling contracts for 7 out of the 10 major insurance carriers. The reason for this decision was based on 4 issues. The first was that we are seeing higher copays that are now exceeding the benefit payouts for each visit. So patients aren't getting much of a benefit from insurance when their copays are $40, $50, $60. Number 2, deductible increases are now eclipsing any cost and treatment plans that we would prescribe to our patients. Number 3, related more specifically to this bill, is insurance visits limits are less than what is needed in order to relieve the patient's symptoms or prevent relapses. Number 4, again, related to this bill, is that essential services like re-exams or extremity adjusting, especially with re-exams where it's required for patient safety, is no longer being reimbursed when services are done on the same day. These are fiscal or financial burdens to most of your constituents, and they pose a very real and significant obstacle to accessing chiropractic care. So chiropractic care is evidence-based. It's been proven in many studies to be safer, more effective, and less costly than drugs or surgery. And so the bottom line is that your constituents shouldn't have to pay higher insurance premiums for less quality chiropractic care or higher costs in chiropractic care. And that's why I'm in support of this bill, and I thank you for your time.
So what is in this bill that's different than the chiropractic mandate that we already have in our statute?
This promotes 20 insurance visits.
But in terms of, doesn't solve the problem of the copays, deductibles, and anything like that.
Fortunately, it doesn't.
All it does is go from 12 to 20.
It also hopefully will cover more services that are essential, like re-exams and extremity adjusting and maybe some other
But
ancillary
isn't that in the
procedures.
12, or the 12 was just maintenance?
No,
So-
in the
I
bill.
don't say in the current law. What's it?
Correct.
Okay. Right. Just trying to understand the difference. Okay. Questions? Great. Thank you. Okay, I'll switch back to an insurance company. Peter, you're on.
Thank you, Mr. Chairman, members of the committee.
I see some familiar faces and lots of new ones. For the record, Peter Bragdon, I'm a senior policy advisor with Preddy Strategies, representing Harvard Pilgrim Healthcare, a not-for-profit health insurance company. I think perhaps the only not-for-profit insurance company, certainly the largest not-for-profit insurance company. And though we're opposed to the bill, we are strong supporters of non-opioid pain management service, as evidenced by the fact that we offer a wide variety of these services to our members already. And we're opposed to the bill for 5 reasons. First of all, and some of these were covered by Heidi earlier, so I won't go into much detail. But first, we feel it's not needed because, as noted, we already cover a wide variety of non-opioid pain management services. For instance, all of our plans cover physical therapy, occupational therapy. All of our individual and small group plans cover chiropractic, acupuncture, as well as we also cover a wide range of non-opioid medications themselves as alternatives. So these are already provided. We don't provide coverage for mediation services provided by somebody external. However, as Heidi mentioned, we do have a website available with a lot of resources on mindfulness and mediation resources, including articles and actual recordings of guided meditations. So we provide alternatives where we can, especially on the areas where it might be tough to find as was brought up before, licensed providers. Although chiropractors and acupuncturists are licensed by the state, there's a lot of things on here that are not. And so we provide some resources to help in that area. The second reason we're opposed is certainly creates mandates, and we feel mandates increase costs. One size does not fit all. We offer a variety of plans with various benefit levels, including different coverage levels for things. Allows us to meet the needs of our members while also allowing them to meet their budgetary needs. As mentioned before, requiring services as the bill is written for 20 visits for each of a dozen or more different types of services will certainly be a significant cost increase. And as mentioned, also would also impact the state budget because there's 50,000 people that get their insurance off the state exchange, for which the state would have to pay for any of these increased costs in premiums as a result. Number 3 reason, lack of credentialing, licensing, and oversight. We are strongly opposed to any coverage mandate where we would not be able to determine if the provider is safe and qualified to treat our members. As I mentioned, some of these services on here are already licensed, and we cover those. So chiropractors, acupuncturists, etc. But there's many that are not. Similar to that, discussed before, was the need for evidence-based services. We have a duty to our members to make sure we are covering services that have been studied to determine they are effective and cost-efficient, because after all, it's those members who are paying for it. So we look for evidence-based studies to show that these are effective and efficient services. And for many of these things listed in the bill, we are not aware of any broad studies proving that these services are effective or cost-efficient. And finally, this bill goes beyond, well beyond what other states do. It was represented to you that a similar bill has actually passed in Massachusetts. The Massachusetts law requires carriers to ensure they cover at least 2 alternative medications and at least 3 non-medication treatment options. It doesn't specify which ones they have to cover. It allows the carriers the flexibility they need to determine the mix of services. This bill prescribes dozen or so treatments that have to be provided to everybody. The Massachusetts bill is nothing like this. So for the reasons stated above, we support alternatives to the pain, non-opioid pain services, but we feel this bill just does not get our support. Happy to answer any questions, Mr. Chairman.
So did Harvard support that Massachusetts bill?
I was not registered as a lobbyist in Massachusetts.
I
Mr.
know you're
Chairman.
not.
I cannot tell you.
Right. Well, I guess the question is were in that mandate, it was 2 and 3.
Yep.
Were those things that you guys offer? Would you be able to comply with that if we had passed that in New Hampshire? Would you be?
If we'd be able to comply with it,
Yeah.
because I think we already do offer these alternatives.
Bingo. Okay. Yes, Representative Herbert.
Thank you. Do you know of anybody who's done what I would call research on the exogenous effects of not providing this these services?
Research on what?
Exogenous. In other words, it's like the oil industry. They don't have to pay for the pollution that's created by oil. And I'm trying to think if anybody's, and there are studies on that. I was just wondering if there are any studies that somebody attempted to go into and do a study where the services are not provided and the impacts that creates, the costs that creates, whereas they could do another study that would show that those costs were ameliorated. These are external costs that are not put into the budget, is what I'm getting at.
Right, right. So thank you.
I'm not aware of a study that does that. We get a lot of anecdotal, in fact, I don't know anybody that couldn't give you an anecdote that yoga or stretching on your own in your living room has helped relieve pain. So, but it doesn't sound to me like anybody's actually done a serious academic look at these external costs.
Yeah, thank you for your question. I'm not aware, certainly the sponsor of this bill maybe can shed some light on that as well. I will mention too, something I note I made during some of the testimony is you had a lot of anecdotal incidents brought up where somebody who was 70 years old got this treatment and wouldn't be able to. A number of them, all the ones I heard dealt with people on Medicaid. This bill doesn't affect anybody on Medicare. Not Medicare, not Medicaid, not vets, not large self-insured groups. It was mentioned that only, I think, 9% of people in the state qualify for coverage for one of these services. But remember, we're only dealing with individuals in small groups. That's just only less than 25% of, and the carriers, as far as I know, Harvard Pilgrim certainly does, and I think all the other people in the small group and the individual market already cover all these. So you're really trying to address something that you have no authority over: Medicare, Medicaid, veterans, et cetera.
So the answer is no, nobody's done an academic study on the external costs.
I'm not aware of anything, but it's not my expertise.
Fair enough. Okay. Thank you very much.
Thank you, Mr. Chairman.
Okay, Dr. Dan from the Chiropractic Association, what's it? Oh, yeah. He has a very nice signature, but I don't know what that last name is. Is it Parent?
That's my best writing.
Is that Parent?
Parent, yes.
Okay, so I did
Thank
get
you.
it.
Thank you,
All right.
Mr. Chairman. And thank you all for your time. Thank you for allowing me to present today. My name is Dr. Daniel Parent. I am here. I'm the Vice President of the New Hampshire Chiropractic Association. I am representing my colleagues and my patients, your constituents. In regards to my support for House Bill 303, I think I'd like to focus on the 20 visit limit. Chairman Hunt, I believe you spearheaded the 12 visit limit for us back sometime.
I was in the room.
Okay.
I'm not sure that I
there was rumors,
I
so I
actually
had to bring
voted
that
for
up.
it because my fear was that a company might choose not to cover chiropractic anymore once we mandated that 12. And sure enough, Cigna dropped it at the time. So
Got it.
that was my concern.
Understood. Thank you. Well, we appreciate your effort on that. Just being in the room helped. Thank you. In regards to the 12 visit, in my practice of 28 years, what I find clinically is that people that come in chronic or acute pain, it takes approximately 12 visits, 10, 12 visits to get them somewhat out of pain and get them somewhat functional. The additional 8 visits, and that's all this is asking for, is an additional 8, which we're not asking for extended period after that, but 8 will allow us the time to help them change lifestyle habits, help them incorporate postural exercises, help them utilize and incorporate lifestyle things outside of the office to help them stabilize their condition so they're not returning on a regular basis with the same condition repeatedly over and over and over again. I had something written out here, but I'm going to digress a little bit. And we didn't talk much about lifestyle. We did earlier. 2 of the presenters talked about lifestyle change and the upside down pyramid. And while we might have additional drugs that might replace opioids, I still believe we're going in the wrong direction. If we take a look at lifestyle first, and while there may or may not be evidence-based in regards to the efficacy of yoga, my patients who do yoga on a regular basis and incorporate it into their daily routine and lifestyle, I can guarantee you they're healthy. I can guarantee you they're healthier than those who sit all day. Sorry. And listen to us. Okay? Qigong, the same. It's when we start to give our patients the power to make their own choices outside of our offices, but also give them options that they may not be aware of. With yoga, with Qigong, with chiropractic, with nutrition. What are you going to do for yourselves to help keep yourselves out of the system? Because we know the system chases symptoms. We know it does nothing for the most part to help them become healthy and live their lifestyles the way they should or want to. I still believe that we're looking at the system from the wrong angle. Now, in regards to evidence-based, my question is, was there evidence-based research that proved the efficacy and the possibility of even the addictiveness of opioids? Is there an evidence-based study that proved those things, but they were still allowed to be put into the system? And where my cousin's 16-year-old son had a football injury in high school, and he's now dead from overdosing, I'm sure there was evidence that said it's okay to give this 16-year-old injured athlete a drug to mask his pain, but not to deal with his life and his lifestyle and deal with the issues that brought him in there in the first place, and go towards the issue itself instead of masking it. He could no longer get opioids, so he ran to heroin. And he left a 5-year-old son. So I don't think we're asking for much in this bill. I know these things have been brought up before. We talk about cost effectiveness in regards to chiropractic. We've been in front of this committee numerous times showing research after research after research study that shows the cost effectiveness of chiropractic care and its evidence-based value, yet it continues to get kicked down the road because costs seem to be the issue. I don't believe costs to be the issue. If you start incorporating lifestyle concerns and giving people the power to make their own choices outside of our offices, you're going to see a change in the system. Yet we don't do that. Some don't do it, some do it. Here, take this, take it home. But continue to sit, continue to eat what you're eating, don't exercise, don't meditate, don't be mindful, don't learn how to breathe the right way. Okay, it's our responsibility as individuals to take care of ourselves. But I think we need a better system to guide us because most don't know where to go. Most don't know how to take care of themselves. We didn't come with a owner's manual, if you will. This, I believe, has spearheaded that. We need to start incorporating in our society these types of things. Okay? Instead of relying on the same old, which has got us this place in the first place. And if you want to talk about cost effectiveness, keep doing the same thing now, costs continue to rise. The deductibles go up, the co-pays go up, our premiums go up. So if we want to talk about cost effectiveness, this isn't working because our costs per person continue to rise in regards to healthcare. Now that might be linked to business, that might be linked to other things as well. But if we started educating our people, our constituents, our patients on alternatives to take care of themselves better, we might be in a different situation. I thank you all. That concludes my testimony. If anybody has any questions, please ask.
Thank you. That was very compelling.
Yeah, I have a question.
Yes.
Yeah. Outside of thank you for taking my question. Other than pharmacists, alternative medicine, there are several, not doctors, that will prescribe what you're talking about. How would an individual or a student or learn more about alternatives to medication?
TikTok. No, I'm just kidding.
Yeah. I mean, it sounds like,
Oh, no.
it sounds like if you don't go to a chiropractor, you don't really,
a
or
dance?
know someone that goes to a chiropractor.
Right.
You don't get that understanding of alternative, not medicine, because I don't believe it should be alternative medicine. I think
Right,
it should be
right.
alternative care.
Right.
So where
Complementary
would that
care.
education come from?
You've got to find it. You've got to find it. The same thing with teaching my adult children about how to use their money and invest it properly and not pay fees over fees over fees. You've got to find ways to do these things. It hasn't come to the forefront. It's not on the media. And I'll say that it's not on the media doesn't teach it because they're funded by people that don't allow it to be taught. So for us, it's right now as individuals, as practitioners in this room that support this bill, it's up to us to do it. And it's a small group. But until this becomes mainstream, we're going to have to find it on our own.
Thank you.
Thank you.
Thanks. Oh, we do have a question. Sorry, Representative Peter.
I understand when you talk about going from 12 visits to 20 visits in order to get some maintenance and more stabilize the patient. But this bill is down at the insurance company level. How is that going to help? And several of the insurance companies already talked about they cover some of these things in various different ways.
Right.
And that in fact the bill is only going to cover 25% of New Hampshire subscribers anyway, because Medicare, Medicaid, they won't cover it.
Right.
Do you think that the medical profession itself has the responsibility to inform people of these kinds of things, not insurance companies? I'm not clear on why the insurance company is responsible for that as opposed to the medical profession.
Right.
That's where I've learned everything from.
Right. I think we took an oath to take care of our people.
Right, but
Right.
but this bill puts the onus on the insurance company.
And I believe that the bill puts some of the onus, which again, in regards to cost effectiveness in chiropractic, is very minimal. And we've proven that, and we've brought those studies to this committee numerous times. To answer your question in regards to as a healthcare professional, it is our responsibility, but I know a lot of healthcare professionals that don't exercise on a daily basis. And I've watched what they eat. And I watch how they don't get sleep and meditate and be mindful and take care of themselves and stretch. And so again, goes back to the question, how do people know? Some of the physicians don't even know, and it's a journey, really, I think, for most. And you've got to figure out what works for you and what doesn't work for you as an individual.
Representative Burrows.
Thank you. And so would you believe, I think that some of this starts in medical school, that I think a lot of physicians in training and other people in the medical profession are not given information. They're not trained in these other methodologies and treatments, so they don't know about them. My husband is 72 years old, is a physician. He couldn't get a class in nutrition back in the day. So I think some of that falls on educating these people who are in the profession,
Right.
To do that.
Yeah, I believe that too, but in chiropractic college, we didn't learn about meditation, yet I practice it every day. We didn't learn about, well, we did learn about nutrition. Actually, we learned a lot about it, but not quite as well as I own it today. So I think there's still a lot missing in education that could be improved. But if we can help our patients and constituents and yourselves and everybody sitting behind me make better choices to hopefully stay out of a system, right, that doesn't promote health and well-being, I think it's a good start.
Great. Thank you very much.
Appreciate you.
You're on. Yes.
A meeting I had to start. Thank you for the chance to speak briefly here. Just making sure I'm muted. I'm Sabrina Dunlap. I'm Director of Government Relations for Anthem. And I missed what Harvard Pilgrim had to say. I'm guessing that we echo a lot of what Peter said, certainly echo a lot of what Heidi said. I did want to just emphasize that we were among the people at the table for the ad hoc committee. We're certainly open to conversation. We cover a lot of services that are in the realm of pain management. I think the licensing piece is key. It's just a practical problem that if you have a provider that's not licensed. There's no way to really credential them and sort of bring them under clinical services. So it's not that we're, philosophically opposed. It's more of a practical issue. So I wanted to flag that.
And we do have the board certified requirement in our statute.
Okay, yeah. So, sorry, I'm just switching gears to this. So yeah, and just to reiterate, we do cover chiropractic services, osteopathic, manipulative treatment, acupuncture, OT, PT. It's really when you get into yoga, qigong, tai chi, and meditation, that those things are sort of outside the clinical realm at this point. So anyway, so that's all I have. I'm happy to answer any questions. I'm sorry I'm rushed.
Okay, anybody want a chance to ask Anthem? This is your chance.
Well, thank you for the opportunity to speak.
Yeah, no problem. Okay, I assume the lady from the Medical Society did?
Yes.
Oh, great. You're
I am back.
the other.
I am back. And I do apologize that I missed a lot of the discussion. I don't want to be redundant.
Tell us your name.
I'm sorry?
Your name?
Seddon Savage. Yes.
Seddon
And I am here to testify on behalf of the New Hampshire Medical Society. And I am a pain medicine and addiction medicine physician. I've been practicing in New Hampshire for almost 40 years. I'm no longer in clinical practice, but I'm still working in education within the Dartmouth Health System. I'm not testifying on behalf of Dartmouth, however, just the Medical Society and myself. And I am enthusiastic about this bill because since the early 1980s, I have been working to try and integrate care and provide multimodal care of people with chronic pain and sometimes with co-occurring addictive disorders, including opioid use disorder. I have served as director of an outpatient pain service in an academic center. I've been privileged to work in the VA system was privileged to work for 14 years. And I have been medical director of a residential treatment center that actually was able to implement multimodal, intensive, integrative care and see patients come off of opioids and, in fact, all medications and manage their pain through active lifestyle changes, including meditation, meditation, exercise, and other modalities. So I've had a lot of different perspectives on this, and it's from that I really do support this work. I've also had an opportunity to serve as president of the American Pain Society, which has been an interdisciplinary society that brings together people from different perspectives to treat pain, and been in advocacy for this. I think that this bill, if it's passed, and I'm pleased to hear that most of the people who are testifying on behalf of it, even the insurers, like the spirit of the bill, but it's the details that are hard to work out. But from my perspective, if this bill passes, it will markedly improve quality of life for people with pain. It will reduce reliance on opioids for the treatment of pain. And I believe that it will likely actually reduce costs over the long run, particularly for people with chronic pain. And why would that happen? Well, if we understand what pain is. Pain, whether it's acute, such as surgical pain or that associated with medical illnesses or severe trauma, whether it's acute pain or whether it's chronic pain due to chronic conditions that perk along, or sometimes chronic pain, we can't identify the cause of the pain, the tissue cause of the pain. Whatever the pain is, it is an experience, and it's shaped by very diverse biological factors, by environmental factors, psychological factors, and social factors. So whatever the originating cause, usually in the tissue somewhere, that signal of injury is sent through the nervous system, and it can be either amplified or it can be turned down or inhibited at many points along the way, depending upon the chemical environment in the body, what drugs are present, what levels of certain natural body chemicals like epinephrine or other factors are present. It can be changed as it travels through the brain by thoughts, by feelings, by cognitions, and then it arrives at the brain as either very severe or negligible, depending upon how it's been processed by the nervous system. And that's why we talk about understanding the pain and active role in managing the pain, because there are things that individuals can do to really change completely the nature of pain. So we know that some people who have serious tissue injury, major trauma, surgical, recovering from major surgeries, sometimes have little or no pain, and other people where we can't even find a reason for the pain may experience enormous pain. And people who have chronic pain, it may vary from day to day, again, depending upon contextual variables, how they're feeling, and what behaviors they're engaged in. So the diversity of shapers of pain, contributors to pain, mean that in order to have an effective pain treatment plan, we really have to help understand the contributors to that experience of pain, and then have a really broad array of tools that we can use for tailoring our pain management plan to the particular individual. I usually think of our tools in large buckets, and I think you've heard most of these, but psychobehavioral treatments such as cognitive behavioral therapy, mindfulness. There's a new one called pain recalibrating therapy, where people actually turn off the signals of pain, learn to turn off the signals of pain. There are physical approaches that we've heard about, physical therapy, manual therapy such as chiropractic, osteopathic manipulation, and movement therapies we've been discussing. And importantly, individualized exercise on a regular basis. The third bucket, medications, and it's not just opioids, but diverse classes of medications that can be helpful. And then finally, the interventionist procedures, which may include injection therapies, stimulators, and a variety of other things. But no single approach is right, or even no set of approaches is right for any particular condition in any particular individual. It has to be individualized. We can't a priori decide what we're going to provide. Another key element, though, for chronic pain, as for most chronic pain, chronic conditions or diseases like cardiovascular disease or diabetes, is engagement in the patient, in understanding the contributors to their condition, and in having an active role in self-care of the condition. This can reduce symptoms, it improves function, it improves quality of life, and improves the effectiveness of others' treatments, so we don't just continue on long-term on multiple medications or keep going back for more and more injections to get palliative relief. We actually reduce the symptoms and are able to manage the pain over time. So historically, as you know, we've heard over and over today, at least in the beginning when I was still here, I was hearing insurers readily pay for medications and procedures, which are often very expensive and often need to be repeated or ongoing. And for reasons that I've never understood, going back to the 1980s, it's much easier to get a series of very expensive injections approved than to get 10 sessions of cognitive behavioral therapy with mindfulness approved by a licensed provider that might obviate the need going forward for as much medication or injections, or may in fact lead to no use of these other procedures. So I am not persuaded by the insurance company, the insurance department's fiscal analysis that says this bill will increase costs just because it makes more treatments available. In fact, my expectation is that this bill would reduce costs by allowing us more tools to tailor treatment to the individual's needs, to help coordinate that care, because it does ask for care coordination, so that it's implemented in a way that's most helpful to the individual, that we'd stop wasting investments on just a limited range of treatments that may be more expensive and may be less effective for individuals. This bill will really allow us to implement in
effective individualized treatment using a chronic disease management model, which study after study after study has shown improve outcomes for across different types of conditions, and quality of life for people with chronic illnesses, including chronic pain. And in many situations, they reduce healthcare utilization, fewer trips to the ER in crisis or to primary care or to or hospitalizations, and less use of ongoing therapies with greater engagement in self-management of the problem. So this isn't just my perspective. Virtually every organization that's issued pain guidelines has supported a multimodal approach to pain care that addresses the whole person. It's quite simply the standard of care, as I think you've heard from many of the speakers today. And I've been doing this for 40 years, and I'd be really excited to see a change in the way we address pain in our state. I think we can do it, and I thank you very much. And I'm very happy to answer any questions, but I think so many have been asked and answered, you may have none left.
Yes, Representative Spear has a question.
This is a question I've asked already in the past in this session,
Okay.
and I've had pain incidences over my lifetime, as I'm sure many of us do. I was a very
I know.
avid jogger, and so as a result, my hips don't work, my knees don't work. And I've been to all kinds of doctors, but I have never heard a doctor talk about pain the way I've heard about it talk today. So my question is this: why isn't the medical profession pushing this, as opposed to some individual doctors, but the medical profession, instead of trying to push the insurance companies to solve the problem? Because I've been to all kinds of doctors, and they never talk about it like this.
Well,
All I get is the usual typical stuff, and then they give up.
one of the things that I've already heard, I think you say, or someone say in this room, is education is a real problem. And we haven't historically had a lot of education on pain as part of core medical training, nursing training, pharmacy training, or anything else. We hear about it, the drugs that you use for pain, you get it in pharmacy. But what is pain management? That hasn't been a course in itself or a focus in itself, you know. And so that's part of the problem. And there is a big move within medical education now to change that, as it is for addiction, because we also didn't have that. And that's another thing that we've sorely needed. But the other thing is, if it can't be paid for, we often don't pay attention for it, because most of our patients can't afford to self-pay for things. So I think even doctors who are aware of the opportunities for different approaches to treatment don't know how to get them. I think I mentioned earlier, you know, I remember 1986 or 7 doing epidurals and saying, but this isn't going to last unless I can get this, the effects of this may be helpful, but unless I can get this person exercising and managing their stress, it's not going to have any long-term effects. But I couldn't get a cognitive behavioral pain set of group sessions paid for. So I think, you know, we tend to prescribe what is realistic for the patient. So I think it's mutual. I think it has to be both. I agree with you entirely. Thank you.
Okay, thank you very much.
Okay, thank you all.
Oh,
did you?
Representative Amadeus, I have a question.
Thank you for your testimony. Personally, this is the prelude to my question. I find alternative therapies very helpful. So my question goes to the limiting factor in the bill. It seems very open-ended, and so let me explain what I mean by that. The definitional section talks about behavioral interventions, and then it says including but not limited to, and then the manual treatments including but not limited to, movement therapies including but not limited to. So that's very open-ended. So I've been to chiropractors that practice applied kinesiology. I've been to chiropractors that practice something called one brain therapy, which is maybe you never heard of that. I've been to acupuncturists that practiced the Nambudirapod allergy elimination technique. That's probably a pretty rare one. And then one therapy that isn't listed here that's helped me in the past is something called the Alexander technique, which isn't listed, right? So those were all attempts to experiment. I didn't know if they were going to be successful. Most of them weren't. And so if we're going to raise insurance rates by having an open-ended mandate, shouldn't the other people paying into that pool should have a benefit to it as well, right? They shouldn't be paying for things that are experimental, that may not have any efficacy. And so again, back to the limiting factor question, all these including but not limited to statements, someone could put up a shingle that claims to be a pain therapy modality, and this bill, I think, as I read it, would mandate that service would be have to be provided for because it's pain therapy. So, what is the limiting factor? How do we determine when something is effective at managing pain?
I believe, and if I don't have a copy of the bill in front of me, it's back in my seat, but I believe it says effective evidence-based therapy. And I think, we can quibble about what's evidence-based and what's emerging evidence or evidence-informed, but I think that's where the discussion comes between the insurer and the provider. Show me that this has shown promise or has evidence, and isn't just, the latest, let's experiment with this and people don't get better. I'm sorry, I didn't articulate that very well, but I think the discussion needs to be around whether something is evidence-based or not, whether it's demonstrated promise of efficacy in the people in whom it's being used.
Further question?
So if it's a mandate that we're talking about here, that we would need to define that in the legislation, would you agree?
Well, I think what level of evidence has to be present to call something evidence-based is open to discussion. I'm not sure that the legislature can define that. I think that might be a discussion for clinicians or for the insurance department or for others who look at evidence. But I'll give you an example. It's interesting. One of the things that isn't mentioned in here is that emerging pain treatment that I mentioned. And Dave, you may know the name of it, but it's pain restructuring therapy, or it's changing cognition so that at the neurologic level you can block the pain with your brain. There's a new therapy out. It has now 4 or 5 papers supporting its use, and there are more larger trials underway. Whether that would yet be considered evidence-based, I'm not 100% sure. That's open to discussion. But that's the kind of thing that might 5 years from now be named in here, but it isn't yet because it's an emerging therapy with promise of efficacy. Do you see? But I agree with you. You can't pay for everything. You need to have some evidence that it's helpful. Okay? Thank you.
I have 2 more cards yet left.
Oh, I'm sorry.
Usually what I do is at the end, I'll let you come up and clean up. Okay. Heather Marie Brown. Good afternoon.
Good afternoon. Thank you for allowing me to have a few moments to speak, and I appreciate the fact that you guys have been sitting here all afternoon and dealing with many, many bills. The reason I am here is going to probably sound like a unique and interesting one, and probably one that you didn't expect, but I appreciate all of the work that has been done on this bill. I believe that this is an opportunity for the state of New Hampshire to start small and work up to actually covering a larger variety of groups and categories by starting with this bill. I'm here because one of the things that was not brought up in this bill And one of the groups that was not consulted or considered while drafting this bill is the therapeutic cannabis community of the state of New Hampshire. We currently have over 12,000 patients. I believe actually it's closer to 14,000 plus now. And out of that, 70% of those patients are actually on the program for pain, chronic pain related issues. Of that, we have 50%, 70% are for severe pain, 50% are for chronic pain, and 20% are for other degrees of severe pain and magnitude. This bill should be amended to include therapeutic cannabis as an alternative treatment, whether that be in regards to individuals getting the plant access to the plant that they need, or whether that be having appointments for therapeutic cannabis covered in the state. Currently, this is not covered at all by insurance. This is an out-of-pocket cost that can be huge for patients. You know, you are looking at anywhere from $8,000 a year to over $25,000 a year out of pocket, depending on the severity of your condition and what it is you require in order to successfully integrate back into a healthy lifestyle. This has a direct impact on individuals, and a lot of times patients are left having to make decisions on whether they treat their health or whether they or not they pay their bills. You know, I've gone through this myself. You know, what good is it for me to, you know, be able to pay this bill if on my, we'll say my car? What good is it for me to pay the insurance and pay the maintenance on my vehicle if I'm not physically capable of driving that vehicle because I can't afford the medication that I need each month that allows my body to function? You know, we see a lot of individuals that are put in those situations. I realize that this bill does not cover a huge group of individuals in the state, but as I stated, this is an opportunity to start small and hopefully create a trend that we see graduate to cover more and more individuals throughout the state. I don't see this as being a huge issue in regards to how we cover it or how an insurance company deals with it, because fortunately, therapeutic cannabis has probably some of the strictest regulations in the state of New Hampshire as far as how the program is run and operated, which would make it extremely easy to work with insurance companies in order to be able to help patients and to get coverage that they need for this. I realize that there is still a lot of stigma and even discrimination in regards to therapeutic cannabis use in the state, but that needs to not be an issue right now. Just because a person chooses an alternative method for healthcare, they should not be discriminated against having coverage for their healthcare choices. And leaving therapeutic cannabis off of this bill does that. I have had the pleasure to sit on the Therapeutic Cannabis Medical Oversight Board as the patient representative for the state of New Hampshire. We have had a listening session. We have spoken to patients. We have spoken with dispensaries. We have, you know, gone above and beyond in trying to find out what it is our patients need. And the number one issue that is always raised is affordability. This bill, if therapeutic cannabis is added to it, allows the beginning of that to start taking place so that more and more individuals can receive some sort of financial relief. They can pursue their quality of life, and they can have control over their health care. I have not, unfortunately, had very good luck when it comes with my own health care and using modern medications and modern medicine. I was very lucky to be introduced to therapeutic cannabis, and as a result, I walked in this room by myself. I can sit here and speak to all of you and address all of you, and I can take care of my children and my family. Before I found therapeutic cannabis, the only options I was given were opioids or surgery that had a very high chance of leaving me in even worse condition than what I already was. I had to use canes. Sometimes I couldn't even pull myself up to walk. I don't necessarily hold that against the medical professionals, but I do think that insurance companies and medical professionals sometimes maybe tie their own hands when it comes to exploring alternative treatment options for their patients. You know, I am very fortunate to live a much better lifestyle than I did. I wish that there were more options for a patient to be able to have some sort of financial relief. And I would really like this committee to take that opportunity to make a change, to do something as a first, and to amend this bill to include therapeutic cannabis.
Representative Burrows.
Yeah, and I'll admit I just looked this up, but I think one of the problems that we may have at the state level is that this is still a Schedule I drug at the federal level, and which may make it very difficult for any state to allow insurance to cover it. So that might have to be dealt with it there before we can do that.
And to that, I would respond with that there has been a memo that has been issued for several years, even during the Trump administration, even during the Biden administration, that says a state is allowed to do as they choose in regards to therapeutic cannabis, and that the federal government will not stand in their way. And this is an opportunity. We do not have the federal government storming New Hampshire and raiding our dispensaries or incarcerating our patients. You know, this is an opportunity to do something in regards to making a change.
Follow up, please.
For the question you may inquire.
Yeah, and I'm actually all in favor of insurance covering this, just so you know. But I think it would be worthy to find out why, despite the fact that it's legal in 37 states, that insurance is not covering it. I think that might be the next step before we can move forward.
Who knows? The world of marijuana is, who knows how far they're going to let us go. Okay, any other questions? Seeing none, thank you very much for coming in. Vicky Irwin is my last card.
Okay, so I'll go with last but not least.
That's it.
All right, I won't keep you long. As you said, my name is Vicki Irwin. I am a licensed acupuncturist here in the state of New Hampshire. I am a member of the New Hampshire Acupuncture and Asian Medicine Association, although I am not representing them today. And I'm also the new chairperson for the Board of Acupuncture Licensing. So I kind of wanted to introduce myself put some names with some faces, and I'd love to be a sounding board for folks later. Although technically today I am testifying as a professional, not on behalf of the licensing board. But I did want to take a moment to thank all of you for listening all day today, and to the committee members that had worked so hard behind the scenes to put this bill together. My predecessor, Cindy Tirogetti, tried to bring me up to speed on this, as well as HB 66, which is not today's topic of discussion, but something I'm excited to see coming down the line as well. So I'm excited to see this bill to come together. I do own and operate Acupuncture Center of Southern New Hampshire out of Nashua, New Hampshire, and I perform better than 1,700 treatments a year. Most of these are on folks with chronic pain. A handful of them are actually recovering addicts that are just looking for an alternative to their pain medications. Unfortunately, so many of those folks are lacking adequate insurance coverage for alternatives like myself. But I do direct bill insurance companies whenever I can. The vast majority of my practice is, in fact, insurance billing. I have a small handful of prompt pay folks or self-pay folks, and I enjoy seeing them, but insurance is the bulk of my business. While I'm grateful to see a growing number of insurance policies that do offer some acupuncture benefits, I watch my patients carefully budgeting their visits or their units that they're allowed for the year to try to stretch them out over the course of the year. And I really think their lifestyle or quality of life would be greatly improved even by adding just a few additional visits per year, like the 20 that this bill is asking for. A lot of my folks have kind of in the 10 to 12 range. I can usually get them feeling a whole lot better, but then they drop off because they've run out of benefits. And a year later, they're back saying, so I was feeling great, but now I don't. And we're sort of starting over from scratch. In a manner of speaking, I actually think allowing a few extra visits with me would be much more advantageous to the insurance companies than sending them to somebody like our colleague, Dr. Nagel. A $3,500 shot, for heaven's sakes, you could see me 30 times in a year for that. The average amount that I bill out for 2 sets of needles is $117 for a 1-hour visit. That's a lot of shots. At any rate, I do believe that increasing the coverage and a nice multimodal approach like this bill is calling for would benefit individuals in pain a great deal, and also has the potential to decrease the burden of opioid addiction that the state is currently contending with. So I thank you for your time, and I'm happy to field any questions.
I guess we're all questioned out.
I guess so. All right, thank you.
Thank you. Okay, Representative Nagel, you can wrap it up for us. Right, because that's really, yeah, get to turn your mic on. Because that is the reasoning. I mean, in terms of, we actually even have another requirement that you have to be, board certified, but then we back off on that when we got.
So I'm
some of
not
these
gonna,
other,
I'm not gonna challenge you by asking you what your understanding of evidence-based medicine is, but in my book, there's a subsection called evidence-based medicine myths and realities. Because when I started looking at it, it turned out I didn't have a clue what it was. So I went on and asked my colleagues, and the number of doctors who actually knew what evidence-based medicine is was like close to zero. And so I don't expect the insurers to be any better, but what it is, it's the use of the entire body of the medical literature is applied to the individual circumstances of a patient. So we're getting back to this patient-centered thing. A couple of years ago, there was a gentleman who apparently had nothing better to do than he looked at 1,000 medical questions that were in the Cochrane collection, which is the largest collection of evidence base in the world on medical questions. He found out that only 3% of medical questions were answered beyond a shadow of a doubt, which means 97% of the questions in medicine are not answered sufficiently. My concern is this, and we brought this up at the ad hoc group when that issue came up before. I don't mind using the evidence we have to try to do the best we can to say what works and what doesn't, but what I do demand is that we use a level playing field in doing that. For example, surgeons use pedicle screws on a regular basis to do spinal fusions. There is virtually no evidence to support that practice in the degenerative spine at all. I hate to imagine how much money we spend every year to pay for that. But then when we have I'm blanking on the name of it, there's an acupuncture thing that looked at the evidence on acupuncture for 117 conditions and found that it was valid for that. Well, when we're struggling to approve that, we're not dealing with a level playing field. So all I want the insurers to do is say, you know what, we're going to use the same system of analysis for acupuncture, chiropractic, massage, which are all done by licensed therapists, as we would for a spinal surgeon doing, a pedicle screw fixation, or me, Dave Nagel, doing one of his 63,000 epidurals, which, for example, there is virtually no evidence to support any long-term efficacy of an epidural steroid injection unless you combine it with another modality. The only paper that ever showed efficacy was in 1998, and they used epidural injections with a combined approach of behavioral therapy and physical therapies. It was all three things together, not just one. So that's what I'm asking for you guys, and you know that we've talked about that before, and I think that when you use that term, it's really important you know what we're talking about.
Well, I don't even see it in the bill anyway, so.
It's not, but everybody's, you're right, you're right.
So I wasn't gonna go, but no, I think the big issue in all these years that I've been sitting here on this committee is when what I would interpret the evidence base when they're saying evidence base is that there were some studies in which you had a control group.
Right. And you know how few those are, those randomized, double-blind randomized.
All I know is
control-
that that's what they want is that,
most of the
they want placebos involved.
most of the studies that I've ever used to support what I do, George Angle, you don't know George Angle, doesn't matter. So, he's an important person, trust me. But anyways, he said was my personal experience and that. But the other thing is a lot of times it's just some letter to the editor that changes the way everybody does everything, And that's Schedule D evidence. It's not Schedule A evidence. So anyways, I'm done.
It's great. Thank you very much.
Thanks.
Hope you feel like you got a good hearing. Good. All right, for the members, Paula, did you have a handout? And sorry about this all taking so we are going to be getting closer to doing our subcommittee. So please, now that you've heard all kinds of different kinds of bills, make sure you let me know which subcommittee you would like to be on, because I want to get that put to bed fairly soon. Otherwise, have a great weekend, because we're not coming in tomorrow.
And I'm just wanted to mention, I'm Paula Minahan. I think I met you last week. And I didn't have this packet available, but I just wanted you to take it home and review it. It has some interesting information about your hospitals in the state. And my card is here, and I'm happy to answer any questions that you may have about any of the materials. Thank you.